I believe we are too. All of the trustees, I believe, are now in.
All right, very good. Well, good morning, everyone. My name is Alan Steinbrecher. I'm the chair of the State Bar of the State of California. This is our Board of Trustees meeting of the board for this date, Thursday, September 24th. And I'm now opening the meeting. Ms. Secretary, will you please call the roll?
Broughton.
Here.
Chen.
Here.
Cisneros.
Here.
Dela Cruz.
Here.
Dellin.
Here.
Duran.
Here.
Iglesias.
Here.
LeBron.
Here.
Bertula.
Here.
Selig.
Here.
Sowell. Stallings.
Here.
Chair, you have a quorum.
Very much. Mr. McLeod, will you, well, let's do this. I'm going to call for public comment, which is the first item on the agenda. If there are many, I may exercise my privilege as the chair to rearrange the order of the agenda slightly and have my chair report first. However, before I make that decision, I'd like to see how many people would like to make public comments on the agenda items today. So if you would like to make a comment, if you're participating by Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom center of your screen. If you're participating by phone, you may virtually raise your hand by pressing *9. That's the star key, and then the number 9. And again, doing so will alert staff that you want to make a comment. Bar staff will call on those who've raised their hands, either through Zoom or telephone, in the order as best we can determine it, in which you've so indicated your interest. Anybody who's interested should be so indicating now. And Mr. McLeod, do we have people who would like to make public comment?
We do, Chair Steinbrecher. And let me note, I see at this time 5 raised hands. In the past, that's been very manageable, but I just wanted to also just point out that sometimes when we've attempted to work with, say, 5 raised hands and then the additional hands go up, that becomes problematic and we can't get to everybody as they keep on coming in. So it's 5 right now.
Okay. I would encourage anybody who's there who thinks they may want to speak to the board to raise their hands now. You can always decide not to address the board if someone else has already made your position clear. And we would encourage you not to repeat something that someone else has said. So if you do have any notion that you might want to speak to the board, please so indicate now.
And we now are getting many more. Now we're looking at 1, 2, 3, 4, 5, 6. I'm seeing probably 15 to 20 at this point.
All right. Well then, given that expression of interest in commenting to the board, I'm going to, in fact, exercise my privilege as chair and begin with the chair report, after which we will have public comment. I would first like to begin with a very pleasant task. I would like to recognize a longtime and invaluable employee of the State Bar and the State Bar Court, Marilyn Titchener, upon her retirement. The Board of Trustees wants to take this opportunity to recognize Marilyn, who retired last month after an amazing 42 years of service to the State Bar Court. In recognition of her long and important service to the State Bar and the State Bar Court, we have prepared a resolution celebrating her time here, which I would like to read now. Whereas the members of the Board of Trustees of the State Bar of California express their sincerest gratitude to Marilyn Titchener for her 42 years of dedication and invaluable service to the State Bar and the State Bar Court. And whereas Marilyn Titchener has dedicated her entire career to the State Bar Court, starting as an administrative assistant 2 in 1979, quickly being promoted to a senior administrative assistant in 1980, and until her well-earned promotion to deputy director in 1989, which was later reclassified to director administration in 1990, then court administrator in 1997, and ultimately program manager 2 in 2017. And whereas Marilyn Titchener has contributed significantly to numerous State Bar Court projects, committees, and task forces, most notably including the transformation from a volunteer staffed court to the full-time State Bar Court with appointed judges in 2 locations, the creation of the Court Performance Standards Assessment, and the implementation of multiple case management systems. And whereas Marilyn Titchener has managed and vastly improved the administration and operations of the State Bar Court, consistently recognized as, quote, an indispensable contributor, close quote, to its success, quote, invaluable to the judges, managers, and staff, close quote, and, quote, highly respected by colleagues throughout the State Bar, close quote, and has reliably met or exceeded all performance expectations throughout her distinguished career. And whereas, upon the occasion of her retirement, the members of the State Bar Board of Trustees wish to make a permanent expression of their appreciation for Marilyn Titchener's outstanding and invaluable efforts and tireless work ethic. Now, therefore, be it resolved that the State Bar Board of Trustees expresses its deepest appreciation to Marilyn Titchener for her unparalleled work to improve attorney regulation, the legal profession, and public protection. Due to the restrictions imposed by the current COVID situation, we of course can't present this resolution to Marilyn in person, but she has joined us online, and we previously have sent her the framed resolution. Congratulations, Marilyn, and thank you so much for your dedication and significant contributions to the State Bar and the State Bar Court.
Thank you very much, Mr. Steinbrecher, other members of the board today. It's an honor to receive this special recognition and resolution. And I am very honored to have served this board and many prior boards over the years. I want to give special recognition to the gentleman who hired me, former presiding judge of the State Bar Court, Ronald Stovitz, who took a chance on me in the 1970s and gave me a wonderful opportunity to pursue a career in court administration. Following Judge Stovitz, I had other mentors that were court executives of the State Bar Court, Stuart Forsythe, Scott Drexel, and most recently, Colin Wong. I also had a special professor at the Institute for Court Management, Daniel Straub. Those mentors and contributors helped me contribute to California's attorney discipline system. It's really been a good run for me. I've been able to make some meaningful contributions. I'm very proud for the opportunity to have worked with all of you here, other distinguished colleagues and judges. And most importantly, I'm glad to have contributed to California's attorney discipline system for the protection of the public. Thank you very much.
Again, thank you for your service.
Well, you're welcome.
All right, since I have just recognized the dedication and service of a outstanding and longtime employee, I want to spend a couple of minutes to recognize and thank the people who have made this year so successful for the bar. As you know, this is my last board meeting as chair and the end of my 4 years as a member of the board. During that time, the members of the board and the bar's employees, including those of the State Bar Court, have been faced with a number of significant challenges, and it is a credit to all of them that the bar is what it is today, which is, in my opinion, stronger, more focused, and serving the public better than at any other time. The past year has certainly been one of surprising challenges. the unexpected resignation of the former executive director, Leah Wilson, the need to shift overnight from working primarily in the bar's offices to working remotely due to the pandemic, the need to shift, again on a dime, from an in-person bar exam to a delayed and remote exam, the need to establish a provisional licensing program quickly, the wildfires, which continue to disrupt normal operations, and a search for an executive director to replace Ms. Wilson. On the issue of the search for a new executive director, I'm sure everyone understands that that search is a process that is subject to strict confidentiality in order to protect the candidate's identity and their interest in the position. Therefore, I cannot and the bar cannot comment on individual candidates or most other aspects of the search process. But I can inform you that the current search for an executive director has been closed. I expect that the board in the future will conduct a new search for a new executive director. But in the meantime, Ms. Donna Hershkowitz, who has been serving as the interim executive director, has agreed to continue in that capacity. Now that talked about all of the challenges that have been posed to us this year, and I'm really proud to say that in addition to all of those and meeting all of those so well, we've continued to make significant progress in many other areas of importance to our profession and the people of California. The Office of Chief Trial Counsel has continued to improve its key role in the attorney discipline system, including the further reduction of the pending highest priority cases. We have also focused on our discipline systems to ensure that there are not undetected procedures or processes within it that could cause disparate treatment to anyone. To that end, we commissioned 2 studies by experts. We've received the reports and are now working on how best to implement their recommendations. Second, we concluded the California Attorneys Practice Analysis Study, the last of several studies of different aspects of the bar examination that have been conducted over the past few years. Now that that full complement of studies is complete, a Blue Ribbon Commission is being formed to make a comprehensive review of the California bar examination, using those studies as the basis of its inquiry. We have worked hard on improving access to justice. We've received both the Justice Gap Study and the recommendations of the board-initiated Access Through Innovation and Legal Services Committee and have adopted many of their recommendations. We have established a paraprofessionals working group to examine establishing such a program in California. We are also forming a Justice Gap working group to explore innovative ways to increase access to justice for those who need legal assistance, but who remain underserved for any one of a number of reasons. We are looking forward to hosting another Inclusion and Diversity Summit later this year to further the statewide effort to increase both within the profession. And the Government in the Public Interest Task Force submitted its report on an exciting topic, the possible introduction into the discipline system of risk-based analysis of attorneys and their practices with the intent of making the discipline system more proactive and preventative than its current form of being solely reactive and complaint-based. This was a complete team effort, and everyone involved should be proud of what we have accomplished. I therefore want to express my deepest thanks to the many people who made this possible. First, the entire bar staff, who adapted beautifully to the new remote work environment and kept the entire operation running smoothly, while simultaneously meeting the extraordinary challenges I just mentioned and completing all of the important work that I just described. None of what we have accomplished could have been achieved without the efforts of the entire staff, and I want to thank each and every one of them for everything they have done. It would be impossible for me to thank each group which contributed to the bar's success this past year individually, but I do want to recognize especially the incredible efforts made by the staff of the Office of Admissions. Those staff members, under the leadership of Amy Nunez and Audrey Cheng, have worked tirelessly to address the many issues that have arisen in connection with the brand new delivery format for what was to be this summer's bar examination, which will now be given, of course, on October 5th and 6th. They have had to deal with innumerable issues under extremely tight deadlines, with many questions arising seemingly daily. I believe that the bar exam will be a huge success, and I want to thank them especially for all their long hours under significant stress that they have worked to achieve that. A hearty well done to everyone in that office. I would also like to thank the senior leadership team led by Interim Executive Director Donna Hershkowitz, which has similarly kept numerous balls in the air and has ensured that all the wheels stayed on the bar's wagon. Finally, I have to thank every member of this year's board for the outstanding efforts that they have made. I have had the pleasure of serving on a number of boards, and this is the finest that I have ever witnessed for being collegial, respectful of each other's opinions, but not shy about expressing their own. A number of times, the ultimate consensus position of the board after discussing an issue was different than what the initial recommendation had been, reflecting an open and honest debate conducted in a highly professional manner. This was a board functioning at the highest level, and it is a credit to each member that we addressed so many significant policy issues as successfully as we did. In addition, every member of this board was willing to and did roll up their sleeves and work. The amount of time that each of you has put into this year is truly outstanding, and I thank each of you for contributing so much to the bar's success. On a personal note, I want to thank former board member Debbie Manning for her friendship and many contributions to the board during the 2 years she was a member. Debbie brought wisdom and a perspective that was invaluable to the board, and her willingness to dig in and work on issues was unmatched. She worked diligently as a member of the Legal Services Trust Fund Committee Working Group and took on the important task of chairing the Executive Director Search Committee. I want to thank her for all of her contributions to the board, but even more for being a wonderful friend. She will be missed by the board. People have asked me how I feel about leaving the bar. The answer is that it has been a fantastic experience. I have truly been honored to have worked with such intelligent, hardworking, and caring people who are passionate about their work and about improving the provision of justice in California. I'm proud of what we've accomplished together, but I know that the new board leadership of Sean Saleg and Ruben Duran, together with the staff's leadership team and the entire bar staff, will have even more this coming year than we have will accomplish even more in this coming year than we have in the past. Have fun. All right, that concludes the chair's remarks, and now we will go to public comment.
And Chair Steinbrecher, if I may just note, we in our technical challenges, we were struggling to get the newest trustee recently named by the Senate President Pro Tem, Arnie Soule, onto the call, and Arnie has now joined us. So I wanted to note that for all of the trustees.
Well, thank you, and welcome, wherever you are. Okay. All right, let's go to public comment. I understand that we have a number of people who are interested in speaking. The board does have a full agenda for today, so we do not have unlimited time for public comment, unfortunately. I will ask that you limit your remarks to 2 minutes, and to facilitate as many members of the public being heard as possible, I encourage you not to repeat points that were made by previous speakers. The way we will do this is Mr. McLeod will call in order the people who have raised their hands. When you have an open mic, he will begin timing. You will have, as I said, 2 minutes. After 1 minute and 30 seconds, he will let you know that you have 30 seconds to conclude. At the end of that 2-minute period, he will disestablish your mic. So I think that's probably all we need to do to get started. If not, Mr. McLeod, you can fill in, but otherwise the board would like to entertain public comment.
Thank you, Chair. We're going to start in the order that I see the hands raised, and the first hand that I see raised is Mr. Jason Solomon. Mr. Solomon, a microphone icon will appear, and you will have, you'll need to operate that, and you have 2 minutes. Thank you.
Thanks so much. Can you hear me?
Yes, we can.
Terrific. Jason Solomon, Stanford Center on the Legal Profession. I just wanted to speak on the proposed slate for the Sandbox Working Group. I think it's a terrific slate. I think the staff who worked on it should be credited for putting together a great group of people with both expertise and stakeholder representation. I know we don't have a chair yet, but I hope that most of the slate and pending the chair is approved today and that things go forward. I think it looks like a terrific group. I do have one serious concern that I want to call to your attention, which is the lack of consumer representatives, which we talked about last time. So when we think about what are consumer representatives and what perspectives we want represented on this group, right? You're regulating a legal service market. In that legal service market, there are sellers and buyers. There are consumers and providers of legal services. For antitrust purposes, when the FTC gives guidance on this, what they say is that we don't want a majority of active market participants. And active market participants are defined as people who are licensed by the bar or people who are sellers of legal services. By my count, somewhere between 11 and 13 of the 17 people on this slate are active market participants.
Mr. Solomon, you have 30 seconds. Thank you.
Yep. If you look briefly at attachment B, I can show you how this works. A few of the people who are listed as non-attorneys is attachment B on page 17. Several of the people who are listed as non-attorneys, if you look at the first person who's listed as a non-attorney, she's a non-attorney, but she's a seller of legal services. If you look at the two people who are listed as consumer representatives, although they're not licensed by the bar, one has a JD and they're both sellers of legal services. We need more actual consumers. I'm happy to help.
Thank you, Mr. Solomon. Next speaker will be Mr. Art Lackman. Mr. Lackman, once your microphone is available, you'll need to activate it, and you have 2 minutes.
Thank you. My name is Art Lockman. I am a practitioner in Seattle, and I serve as co-chair of the April Future of Lawyering Committee. I speak to you today in my personal capacity. From the outside looking in, and from the perspective of someone who has looked deeply at these issues in a National Association of Lawyer Practitioners and in participating in reform efforts around the country, I have some thoughts about this. Our system tends to focus these issues from purely the lawyer's perspective. It's a bubble. It always seems that it's the lawyers who drive the conversation. The single biggest lesson I've learned in examining and advocating for regulatory reform is that it is crucial that we change the conversation. This means recognizing that what lawyers do is not primarily about lawyers, but rather it's about people of all income levels being able to access legal services. In short, it's all about the consumers. Your Board of Trustees recognizes the importance of non-lawyer participation, and in the same vein, it is inconceivable to me that we can have meaningful discussions about how legal services should be regulated without giving consumers a substantial voice, examining the risks and benefits of any proposal through the prism of their interests, not primarily lawyers' interests. I've noticed in my work that there is often a substantial disconnect with what we protect clients from in the current regulatory regime and what consumers actually think they need protection from.
Mr. Lockman, you have 30 seconds. Thank you.
The result may well be that it is better in some contexts to opt for solutions involving transparency and consent rather than strict prohibitions, or in some cases to eliminate the prohibitions altogether. Consumers need to have a much more substantial voice in this process, and I strongly urge that additional consumer members be placed on the working group. Thank you for the opportunity to express my views.
Thank you, Mr. Lockman. The next speaker will be Mr. Tom Gordon. Mr. Tom Gordon, you have a microphone icon available to you. Once you activate that mic, you will have 2 minutes.
Thank you. My name is Tom Gordon. I'm the Executive Director of Consumers for a Responsive Legal System, also known as Responsive Law. We're a national organization working to expand access and affordability in the legal system. I'd like to echo the comments of Mr. Lockman and Mr. Solomon, particularly Mr. Solomon's note about the overwhelming majority of potential nominees to the committee being lawyers and otherwise being market participants. I do want to repeat some of the concerns I raised along those lines and some of the suggestions I made back in July when the working group was approved. There is a supermajority of lawyers on the slate, which would provide a lot of red meat for the FTC or other antitrust enforcement, especially because there are spots reserved not just for lawyers generally, but for particular market segments of legal service providers, such as the California Lawyers Association, a consumer attorney representative, California Defense Counsel, California Legal Services Lawyer, National Legal Services Lawyer. And note, by the way, that a consumer attorney representative is not themselves a representative of consumers, they're a representative of consumer attorneys. And in addition, as Mr. Solomon mentioned, the 2 consumer spots are also filled by service providers. So in July, we recommended that the trustees add actual consumer members to the panel, specifically 6 of them to offset the spots held by representatives of the legal profession. And so we would suggest once again that you add 3 consumers, individual consumers from a range of socioeconomic backgrounds, a small family business owner, a medium business owner, and a large
Gordon, you have 30 seconds.
And if the trustees are unable to find individual consumers to represent these spots, they should fill them with non-lawyer representatives of these constituencies rather than lawyers who may happen to represent these people as clients. That way we can have representation from the actual voices of consumers rather than from the voices of people who provide services to those consumers. Adding these 6 slots would also turn a 12-11 majority of non-lawyers, sorry, an 11-6 lawyer majority to a 12-11 non-lawyer majority.
Thank you, Mr. Gordon. The next speaker will be Mr. Kyle Jackson. Mr. Jackson, you have a microphone icon available to you. Once you've activated that, you'll have 2 minutes.
Okay, can you hear me?
Yes, we can.
Okay, well, hi, my name is Kyle Jackson. I obtained my license to practice a few years back, about 7 years back. And the reason that I'm on this call today is I've been in communication with Omar Easley and some other people from the State Bar about trying to get a refund for State Bar fees. For many years, I could not get a job as a lawyer. And during this coronavirus pandemic, it seemed like the one opportunity to finally take a stab at it. I opened an online law practice, a website dedicated to trying to help people apply for pandemic unemployment assistance. It didn't work out quite as I expected. That's all right. But in order to do that, I needed to pay back an enormous amount of fees to the State Bar. And I hoped that I might be able to recoup that by opening a law practice, but it just hasn't happened. And I understand that the decision will be made today by the Board of Trustees, and I just wanted to speak on my own behalf because I feel like this is a time where young lawyers in this generation are struggling very hard to get jobs as lawyers.
And Jackson, you have 30 seconds left.
Yes,
Thank you.
No problem. And it's been really difficult to just always pay fees. And at one point I stopped and I had my license suspended. And I thought this would be my opportunity to get back into it. And just the fees have really been difficult to pay. So thank you for your consideration.
Thank you, Mr. Jackson. The next speaker will be Ms. Claire Salute. Ms. Salute, you have a mic icon available to you, and it appears to be active.
Good morning. It's a pleasure to see you all again. Many of you are familiar with me from my attendance at the Provisional Licensure Working Group. And my comments are really based on my attendance in terms of seeing a lack of representation from the legal aid community on that working group. And from what I'm hearing, that's not unique. So I'm encouraging this group to think long and hard about the importance of legal aid representation on all of your committees, as access to justice and serving those who are at the lowest economic position in our society is truly one of the highest callings of attorneys and the State Bar. Related to that, as many of you know, I run a legal service funder network, which has over 70 different organizations in the Bay Area affiliated. And we have yet to be engaged in terms of public-private partnership with the State Bar. We'd love to do so. And so we encourage you to reach out to us and to other organizations in the philanthropic sector that want to support legal services and the work that it does. Thank you.
Thank you very much, Ms. Salot. The next speaker will be Mr. Toby Rothschild. Mr. Rothschild, and Mr. Rothschild just disappeared from the queue. So we're going to move directly to Asita Rahim. I hope I pronounced that correctly. There's a microphone icon available to you. Once you unmute that, you will have 2 minutes.
Hi, can you hear me?
Yes, we can. Thank you.
Hi, my name is Azita Rahim. I'm an examinee that has met the 1390 cut score and would request that retroactivity be applied to that new cut score. However, we have been inclined to the last PLL group where Mr. Gupta suggested that the PLL group be applied to this unique group that has met the 1390 cut score. And in applying this new program, we request that it be applied expeditiously and that minimum hours be required for attorney supervision. And the elements to this PLL group differ from the one that's being applied to the 2020 graduates because this unique group has already met the new cut score and has shown competence. And furthermore, lastly, once the PLL group does get applied, we would suggest that the last part would be waiving the bar for this group because they have met this cut score. And there are over 380 students that have met this cut score in February 2020, and more students that have met this cut score based on HR 103 in previous years. And we would request this group and the Supreme Court to take this motion quickly because there are examinees that are sitting for the October exam that shouldn't be sitting for this exam and taking this exam again and proving that they are competent once again. Thank you
You
so
have
much.
30 seconds. I'm sorry. Sorry for interrupting. You just concluded?
Yes, I did. Thank you.
Thank you. The next speaker will be Mr. Fernando Orozco. Mr. Orozco, you have a microphone icon available to you.
Yes, this is actually, it shows different name. My name is Gabriel Buelna. I took the bar in February 2020 and I did receive over 1390. I am echoing the previous speaker with regard to supporting retroactivity, but in the alternative, the provisional licensure, and also that it be expeditious, but I wanted to add that right now there is extreme economic despair going on in the state of California. You know, those of us who have received over 1390, there is a lot of suffering that's going on, and this could alleviate a lot of suffering for thousands of individuals with that the safety of the state is not at risk because of the 1390. We understand that there are going to be additional requirements. That's fine. But the other thing that I wanted to call to your attention is, you know, the mode of the test. Yes, it's online. You know, I received a 1435 on the first read in February. But I have a condition called a vision condition called congenital nystagmus, which makes it that reading specifically of the three components of the essays, the MBE, the performance test, even for those that have good vision, physically navigating the performance test will take an additional 5 minutes. Those of us who have vision issues, the PT literally is going to be very complicated and likely going to take at least 10 to 15 minutes because individuals with vision issues, like mine, which creates blurriness.
You have 30 seconds remaining. Thank you.
Which creates blurriness looking at the thing. So this is not a complaint, not trying to get away with not doing something, but many of us will not be able to do the PT as it's physically, and the representation of individuals with disabilities, it's going to be very important that you take that into consideration. You have a remedy in front of you. Thank you very much.
Thank you very much. The next speaker, I only have a single name on it. It is Malisa. You have a microphone available to you, and
Hi, can you hear me?
yes, I can.
Thank you for taking the time to listen to our comments. I'd just like to also take the opportunity to please encourage you to consider expanding the provisional licensure program to include individuals, as Azita and Gabrielle have said, who have previously scored a 1390 with an exam waiver upon completion of some sort of specified reasonable set of requirements that allows for timely admission as a full licensed lawyer in California. As my colleagues have said, we as a group have already demonstrated we have achieved the level of competency required to practice in California. And as all applicants are facing unprecedented challenges, as we near the bar exam, we also are in a unique position with less resources and less support from law schools that we've graduated from a year, 2, maybe 4 years ago. It would be in the best interest of all of those who are qualified to be able to obtain licenses to practice and help our communities as quickly as possible. Inclusion of this group of diverse applicants would also demonstrate the State Bar's commitment to diversifying the profession and breaking down historic barriers. Thank you very much for your time.
Thank you. Our next speaker also has a single name here. It's either Edie or Eddie. Your microphone is available and you will have 2 minutes.
Yes, thank you. My name is Edie Sussman, and I am an attorney in Sonoma County. I've been practicing for nearly 40 years, just under 40 years, a public interest attorney this entire time. And I want to echo the voices that have just been heard by those former examinees who have scored above 1390. And I would echo what the path they have suggested that the trustees take to ask the Supreme Court to allow for a waiver and different rules. But I want to comment with due respect to these former examinees to a different set of circumstances that I think the trustees should consider. And that is that our community is hurting. We have had wildfires for the last 3 years. We have had this pandemic. We have a huge population of underserved community members who need these competent young people to step in and help us. I can tell you, I am on the ground. I am dealing with this daily. And in addition to the examinees, it is just wasteful to not have these young folks out there helping our community and working for them. I am personally aware of at least 3 of these former examinees who've scored above 1390 who are just waiting to walk in and do the pro bono work and the legal aid work and the community service work that we desperately need. So I urge you to do the right thing. There is no reason to waste these valuable young minds and efforts that are so needed in our community to address the serious issues that we are facing and that we will continue to face because of the pandemic. And quite frankly,
you have 30 seconds left. Thank you.
Prior to the pandemic, our county was already struggling with homelessness issues and medical care issues, mental health issues. We need these folks. Please put them in a position, or ask the Supreme Court to put them in a position to help their community. Thank you.
Thank you. The next speaker will be Sanas Nikbaksh. Once the microphone's available, you'll have 2 minutes. If you'll unmute it, please. Your microphone is still showing as muted on my end, and your hand has been lowered, but your microphone is now up. Okay.
Hi, I am one of the 397 bar examinees that took the exam in February 2020, and I have met the new lower cut score. I would just please urge the committee to consider retroactive admission for the exam takers that took the exam in 2020. I still have not been able to download ExamSoft. I have spent the full day yesterday and the day before contacting CalBar and ExamSoft. I have 2 children at home that cannot go to school because of the school closures, and My husband has been at home, so I do not have a quiet place to study and or take the bar exam, unfortunately, because all the coffee shops and libraries are closed. Studying is made difficult. I have been approved to take the exam in person, and I'm scared to contract COVID. And I would just urge the committee to take into consideration that when I did take the exam in February 2020, this virus was very prevalent at that time. While I was taking the exam, there were several bar applicants in the same room that I was taking the exam.
You have 30 seconds left. Thank you.
Coughing and possibly having COVID. And I would just urge the committee to at least consider the applicants that took the exam in the same year and where the score was lowered within 2 months from the time that we took the exam, for us to meet the same competency requirements, but with all these other hurdles that we are currently dealing with as far as work, society, and I am a volunteer at the Self-Help Center, and
Your
I'm
time is
ready
up.
to go.
I'm very sorry. Thank you very much for your comments. The next speaker is listed as Matt. Matt, your microphone is available. Once you unmute it, you'll have 2 minutes.
Sure. Hi, my name is Matt Spolsky. I'm a 2018 graduate. I've taken the test 4 times now, and I've gotten over a 1390 on the last 3 exams. I didn't really care which date was selected with retroactivity because I felt like I would have passed or been awarded my license on any time. The provisional licensing requirement sounds great to me. I'm probably different than most, whereas if you set up a 2-year requirement where I'd have to be under somebody's supervision, that'd be fine by me. Obviously 6 months would be preferred. I know that's what others have said, so I'll leave it up to you, but I think the provisional licensing extension to those who got a 1390 and above would be great. I am obviously more than excited to withdraw from the bar if the bar exam, if the provisional licensing requirement is awarded to us. So I just appreciate your time, but thank you very much.
Thank you very much for your comments. The next speaker will be Mr. Patrick Martinez. Mr. Martinez, you have a microphone available, and
hello, can you hear me?
Unmuted. Yes, we can.
Okay, I am one of the applicants that would actually be applicable for provisional licensing based on the previous cut score 1390 if it is approved. I do want the board to take in consideration that numerous organizations such as the San Diego County Bar Association, East Bay La Raza Lawyers Association, California Association of Black Lawyers, the John Langston Bar Association, the Tom Humane LGBT Law Association, Alameda County Bar Association, the Bay Area Lawyers for Individual Freedom, Lawyers for One America, Asian American Bar of the Greater Association of the Bay Area, as well as Joanna Mendoza, a former trustee of the bar, as well as Senator Scott Weiner, all support retroactivity and all support HR 103, which HR 103 was passed by our legislators for the court to take into consideration retroactivity for 5 years. We are asking that you allow for provisional licensing and make a full recommendation for applicants that scored above 1390, as that would be a happy median with asking for retroactivity and being able to practice at the same time. Please take all that in consideration when you make your decision to go forward with granting provisional licensing for people that scored above 1390. Thank you.
Thank you very much, Mr. Martinez. The next speaker will be Jasmine Martin. Ms. Martin, you have a microphone available and you will have 2 minutes to make your comments.
Hi, my name is Jasmine Martin. I am from the Inland Empire of California. I'm also a mother who scored above 1390 in the February bar exam, which conveniently was the lowest pass rate in the state of California's history of the bar exam. I was studying for 10 months while my daughter was 1 year old, and I scored a 1437, which was 3 points past the mark. Now my daughter's 2 years old, and the daycares are a risky place to put her, and this studying session, this has been extremely difficult, along with the schools being closed and being at my mother's with my younger sisters. And on top of that, aside from personal experiences, the California bar exam has a history of having a disproportionate impact against people of color. And myself as a Black woman is very offended by this, especially considering the fact that you have to score above the national average to even qualify for a second read, which is a 1390. And that has put an undue burden on people of color, on the working class, which I'm a part of as well. And it's taken me away from my work in my community for legal and political research and education, not even giving political advice. And so I know that there's so many people in the public interest that have scored above 1390 that are seeking retroactivity so we can work in our communities and so we can focus on our families and our growth. And this, in refusing retroactivity, will cause undue harm.
Ms. Martin, you have 30 seconds left.
I'm done. Thank you so much.
Thank you very much for your comments. The next speaker is listed as KB. KB, you have a microphone available to you. It appears
Yes,
unmuted
can you hear
now.
me?
Yes, we can. Thank you.
Thank you, trustees, and good morning. My name is Kathleen Beckett. I scored in February on the second read a 1453, which is 13 points above the old cut score. After averaging, my score was 1438. I bring this up only to draw your attention to the mercurial nature of the grading. I too am calling in to endorse Mr. Gupta's proposal that the provisional licensure program be extended to people who scored a 1390 in February. To the degree the bar exam does measure competence, those scoring 1390 or above have proven their competence. Additionally, it is fundamentally unfair to extend provisional licensure to December 2019 graduates who scored below 1390 while denying it to people who have proven their minimum competency by scoring 1390 or above. To the extent that the February exam was impacted by COVID-19, and I assure you that it was, all those that took the February exam were equally affected and adversely impacted. Thank you for your time. I do encourage you to extend the provisional licensure program to February examinees scoring 1390 and above. Thank you.
Thank you very much. The next speaker will be Chantel Johnson. Ms. Johnson, you have a microphone available to you. It appears to still be muted. There we go. It's unmuted. You have 2 minutes, Ms. Johnson.
Good morning, Mr. Chair and board members. Thank you for the opportunity to speak. I just quickly wanted to comment in support of agenda item 708 and the parallel tracks for recommendations for the California Provisional License Program. In particular, the work with a government office agency as an alternative path as you continue your work with what appears to be bar reform, the bar exam reform. The government office, working with the government office provides, I believe, provides greater oversight and accountability, and further increases assistance for low-income individuals that are often overlooked in this work. So thank you so much for the opportunity to provide that comment.
Thank you very much, Ms. Johnson. The next speaker will be Mr. Khan. Mr. Khan. You have a microphone icon available to you, and it appears unmuted now. Mr. Khan? We're not hearing you, Mr. Khan. We're going to move on to RF. RF, your microphone icon is now available to you, and it appears unmuted. Miss RF?
Yes, how are you? My name is Rajesh Fodadar. I'm here to echo all the sentiments of the people who have been speaking before me. I'm a patent attorney. I've been practicing for over 15 years. I've practiced in Boston, New York City, and I've been practicing here in the Silicon Valley area. Based on a Supreme Court decision, I'm allowed to practice before the Patent Office without necessarily having to pass the California bar. Nonetheless, because I take pride in my profession, I want to be part of the California bar. I took the February exam. I took the full one. Had I just taken the attorney's exam, I would have blown away the old 1440 score. But on the second round of grading, as most examinees suffer, I just got completely obliterated and murdered on the second read. I was still able to stay above 1390. I think it would be great if retroactive admission is not given, that you allow examinees like myself who have scored 1390, also examinees who scored 1390 on their first read, some avenue to just get their professions started. I think it would be an actual great benefit to everyone to see how new innovative licensing regimes can take effect. I think there will be a lot of positive unintended consequences for the community. I think you'll see a lot of attorneys gain new skills, and also a public that will be exposed to different lawyers at different stages of their careers, as well as other lawyers being exposed to other lawyers at different stages of their careers. I think there's such a win-win-win in this possible approach that it's absolutely one of the best ideas I've heard this summer, other than retroactive admission. So, you know, I'm really privileged. I
You have
work.
30 seconds left. Thank you.
Yeah, I'm really privileged. I work. I make great money in my career, but I can't imagine the stories that I'm hearing about the other examinees, and my heart goes out to them. But anyway, thank you very much for your time.
Thank you very much. The next speaker will be Selena Copeland. Ms. Copeland, your microphone's available.
Hi, this is Selena Copeland, Executive Director of the Legal Aid Association of California, and I just have a very brief comment. I wanted to encourage the paraprofessional working group to continue to engage the legal aid community to better understand the capacity of those programs to serve lower income individuals who are between 125 and 200% of poverty. That the primary purpose of the legal aid community is to serve the lowest income Californians and seniors and people with disabilities. Many organizations are able to make use of other government funding to serve clients with income levels above the poverty rate. So I understand that one of the goals of the paraprofessional working group is to figure out ways to increase legal helpers for people who cannot afford an attorney. So thank you to committee leadership for scheduling a future meetings to discuss the Justice Gap study as a way to dive deeper into the need before returning to discussing possible solutions. And one quick note on the provisional licensing working group, because I know a lot of folks are interested in that. I just wanted to thank the group for accepting a few of our suggestions, specifically the reduced fees to participate in the program and the allowance of multiple supervisors. This will make supervision much easier for legal aid organizations to hire much easier for legal aid organizations to hire provisionally licensed attorneys and move them to substantive areas of the most need, which right now is housing to the COVID-19 crisis. And I'm going to end there because my children need me. Thank you so much.
Thank you, Ms. Copeland. We're back to Mr. Khan. We appear to have Mr. Khan in the queue possibly twice. I see an Athar A. Khan, so let's see if we can get your audio on this one, Mr. Khan. Mr. Khan, we're still not hearing you. What I'd like to do is I'd like to go to the next speaker, who will be our second to last, assuming that we can get Mr. Khan on last under the other logon. So we have an Andre I'm sorry, I'm going to mangle that. Shevwitz.
Yes, thank you. It's
I'm very sorry for that.
It's Andre Shevsu, no worries. I also just want to support the proposal to consider instead of the retroactive admission for those that have scored above 1390 to be granted the provisional license. I myself, like similar to the other person, interested in patent law, have my career as an engineer, but been trying to take the bar. I took the bar for the first time in February 19. And I can say it was already some imperfect administration with all the stress generated by COVID back then already. And also the July 2019 on the previous year was also an imperfect administration with the leakage of the exams and so forth. So I think this time it's once again the administration of this exam will not be the best method to evaluate examinees. primarily because it's been so hard to study and concentrate, right? I have 3 children trying to work from home, and as you can see from the previous guest, it's pretty difficult to be able to find the necessary focus that someone needs for studying for such a demanding exam. So any idea that tries to reduce the applicability of this exam administration now in October, I think it's meritorious on its face and should definitely be considered by the
You have
state
30
bar.
seconds. Thank you.
Thank you very much. That was it.
Thank you very much. We're going to try Mr. Khan one more time and then one speaker after that, and that will conclude our public comment section. Let's try providing the microphone to Mr. Khan again. The microphone's available and is now unmuted. Mr. Khan. Mr. Khan, I cannot hear you. And I'm seeing shaking heads. I don't think anyone can hear you. We seem to have some audio problem on, I'm guessing it's on your end. We haven't had problems with others. I apologize. We're going to move to the final public comment from speaker listed as retroactive admission.
Hello.
Yes, we can hear you.
My name is Liana, and from the name of my user, I think you can guess what I'm going to talk about. But I want to talk about my situation. I had suffered from grievance of my loved one who died from COVID. And they died overseas, and due to the COVID, excuse me, it's hard for me to talk about this. The financial impact of COVID on my life, I could not even afford a plane ticket to go overseas and attend their funeral. And I took the July 2019 bar exam and I scored above 1390. And due to some personal issues, I could not take the February 2020 bar, but I registered to take the October. However, because of all of these things that happened to me, and in addition, due to wildfire, I had to evacuate. And since I had to do that, then I had no choice but to withdraw from the exam. And so I strongly urge you to consider us, to put us in the provisional licensure program and give us something decent to work with. Maybe we are all okay with pro bono work and additional COE to do that.
You
But
have 30 seconds left. Thank you.
okay, I want you to consider everyone in the last 5 years who scored above 1390 according to your own rule, which is in the past 5 years, all the scores would be valid. Please consider people who got above 1390 on their first read, and please consider people who are already lawyers outside of California. And if you want to put some provisional licensure to somebody who's already a lawyer to work under another lawyer in California. Thank you so much for your consideration and time.
Thank you very much. I see that Mr. Khan is still in the queue and has a microphone activated. Mr. Khan, is there any chance we're going to be able to hear you this time? I'm so sorry we're not able to get to that. The chair has indicated to me that the 2 people who got into the queue after I had said that we would be hearing the final comment, that they will be heard. I have those listed as Ksenia Gracheva, and we'll start with Ksenia Gracheva, and then Victoria will be our final speaker. So starting with Ksenia Gracheva, you have a microphone available to you and you have 2 minutes. Thank you.
Hi, this is actually Mr. Khan. I borrowed a phone from somebody else because I made the mistake of upgrading to the latest Apple OS, and that is really backfiring spectacularly right now.
Right.
So I'm a practicing attorney in Orange County, California, and I wanted to express my support for the latest provisional licensing proposal. But I would want to say one thing. We are less than 10, 15 days away from the bar exam. Having a meeting about this after the bar exam is not going to be quite as effective when we have the opportunity right now to release the pressure that everybody is feeling. All of us on this call here are lawyers. Every one of us knows deep down inside why we passed that exam. It was not an exam of competence. It was an exam of resources. And I think that here we have the opportunity to give people who have already scored just as well as they could have, you know, just let them have the provisional licensing. Instead of making it a 2-year process, let's make it shorter. Let's have this meeting before the exam. And then think about it this way as well. If somebody scores a 1390 in October, they can become a full-blown lawyer the next morning. But somebody who scored a 1390 in February, in the middle of COVID, when we didn't know about it, in the middle of all the other stuff that was going on, in the lowest bar passage in our history, those people will somehow be on the hook for 2 more years of provisional licensing. I'm not sure who in this job market is going to be able to mentor them. I know that I've made that commitment to at least 2 people, but I don't know if everybody else will. And I think
You
we
have
should
30
consider,
seconds left. Thank you.
I would ask the board to consider simply requiring some extra CLE or some other approach that will allow everybody the opportunity to move forward and help everybody who's going to be facing evictions and all kinds of job losses in the coming months. I appreciate your time. Thank you very much. And I hope that you will take this to heart. Thank you. Bye-bye.
Thank you very much, and I appreciate your persistence in finding a phone that would allow you to speak. The final speaker will be, final public comments will be delivered by someone listed as Victoria. Your microphone is now available to you, and once it's unmuted, you'll have 2 minutes. I'm still seeing it as muted. You need to unmute that on your end. I don't believe I can do that. There we go. It appears unmuted now. Victoria?
Hello, my name is Victoria. I'm a foreign attorney. I took the July 2019 bar exam and I scored 1404. I did not take the exam in February 2020 because I decided to put myself through another law degree here in California and received my LLM degree in May 2020. I urge you to extend the provisional license to 5 years as the rules of the state bar allow that. Moreover, I would like to draw your attention to the requirements of the New York bar, which requires the applicants to provide 50 hours of pro bono work under the supervision of an attorney. This can be used here in California instead of 2 years of provisional licensing. This will help low-income families in California as well. Please allow us to work. This will help us and this will help California residents. Thank you.
Thank you very much. That concludes our public comments. I'm going to turn it back over to you, Chair Steinbrecher.
All right. Thank you, everyone, for your comments. The board appreciates you taking the time to express your concerns and points to us. And we do listen and we take those into account during our deliberations. So again, thank you all for participating. We will now go to the next item on the agenda, which is number 10, the minutes. But before I do, I want to not only welcome Mr. Arnie Sowell, who's a member as of tomorrow, but also Christine Ganong, I believe is the pronunciation. I haven't had the opportunity to speak to either of you directly, but I know that both will be participating and new members of the board as of tomorrow, and I welcome you. As I leave the rotating door and you come in, I wish you the best of luck and enjoy the experience on the board. All right, agenda item 10. Oh, and by the way, I did note the start time for this meeting, Ms. Secretary, as 10:38, but I didn't mention it publicly, so I am now. That's the time I have. Thank you. All right. Okay, good enough. All right, we have the minutes of the open session of July 16th of 2020 and the open session minutes of September 4th, 2020. I will dispense with the reading of the minutes if there are no comments, and if anyone has any comments, suggested changes, or concerns about the minutes, please speak up. Otherwise, we will take a roll call to adopt the minutes as presented. Is there any comment? All right, then Ms. Secretary, please take the roll to approve the minutes.
We actually need a motion and a second before I call roll.
Oh, we do? Okay.
This is Jose. I'll move the minutes.
Sonia here seconding.
Mr.
Sonia
Cisneros
Dellin.
moves and Ms. Dellin seconds. And now we're deemed tidy and proper. Let's do the roll call.
Before you call the roll, I just want to make a clarification. Mr. Soul is a member effective today and voting on these items. So I want to make sure he was included in the roll call.
Well, all right.
Yeah, thank you. I was going to make that note myself.
All righty, thank you.
Broughton.
Yes.
Chen.
Yes.
Cisneros.
Aye.
Dela Cruz.
Yes.
Dellin.
Yes.
Duran.
Yes.
Iglesias.
Yes.
LeBron.
Yes.
Fertula.
Yes.
Selig.
Yes.
Sowell.
Yes.
Stallings. Brandon, you're muted.
Yes.
Motion carries for adoption of both minutes.
Thank you. All right, we've already had the chair's report, and so we'll go to item 40 on the agenda, staff reports. The 41 is the executive director, and Donna. You are muted.
Apologies there. Today I'm going to largely forego a traditional executive director report. For that, I point you to my written report that's attached to the board agenda today. But I did want to touch on primarily on one point. With the coming of the new board year, I know it seems far away, but in my mind it's ever present. I've been thinking about the strategic plan and the upcoming planning session. And I've been wondering what the theme of that planning session would be, and what important things we would note that we need to begin to tackle. And I realized, and I want to point out that I haven't shared my thinking with anyone on the board prior to this, but I realized that I believe the coming year will be a year that we really need to look inward and not outward. We have numerous ambitious initiatives that are still in their early stages or only about to be launched. On today's agenda alone, there's a recommendation for a new commission on the attorney discipline system. You're being asked to appoint the members of the Closing the Justice Gap Working Group, and you'll be hearing about the Paraprofessional Working Group, which is still in its early stages. At the last meeting, you approved a charter for the Joint Blue Ribbon Commission on the Future of the Bar Exam. And these are just the new sub-entities. They're important strategic plan initiatives and objectives being carried out every day by the existing sub-entities. I point you to, again, just to today's agenda. There's an item addressing additional MCLE on the elimination of bias, which is a recommendation that's coming from our Council on Access and Fairness to implement a strategic plan objective. Personally, it seems that I have an extraordinary ability to compartmentalize, and that serves me well. But it may be that also makes me less in tune with those who don't happen to possess this same superpower. I was reading just this morning about the burnout and morale issues that many organizations are experiencing in this remote working environment, where the separation between work and home life is less clear. We still have many parents juggling homeschooling with their work obligations, and many families struggling because of the loss of one or more family incomes or even loss of life. State Bar staff is not immune to this. And as a public service agency, we deal not only with our own stresses and anxiety and sense of loss, but those of the public that we speak with every day. A public whose emotions may be running very high and for whom State Bar staff are sometimes the only ones that they can unfortunately take that out on. It's not quite the right phrase that I'm looking for, but the old adage is to work smarter, not harder. That's what keeps coming to mind. I truly appreciate Alan's comments about the staff of the State Bar and all the work that they have done to make this a successful year, and I certainly echo those comments. So with that in mind, I'm going to ask you, the board, that together we continue to think about the best and smartest ways in which the State Bar can continue to meet its critical mission, perform its important job, and serve the public well. That we not keep adding to the burgeoning to-do list, but focus our efforts so that we will perform the very best of our abilities in our continuing efforts to protect the public.
that is my ED report.
All right, thank you. All right, are we ready to go? No,
I can move on to the appreciation to the outgoing chair and members.
sure.
So I have to admit, this is one part of the job that I'm truly horrible at. I'm thankful that your board secretary keeps focus on what agenda items we typically see at what meetings. Otherwise, I would certainly have fallen down on this one. So thank you, Sarah. I will not repeat what Alan said about our outgoing board members. Just know that I feel it too. Renee and Debbie brought so much to the board, and I learned so much from both of them. They deserve to be recognized by this board for their service, their commitment, and their devotion to the mission of the State Bar. I personally will miss having each of them as a sounding board, a voice of realism, and a true voice of the consumer of legal services. But I'm still pinning my hopes that I will be able to twist Renee's arm to hold over a little bit longer until the governor is able to fill her seat, and that we may continue to see her face at that November board meeting. We do have one additional board member, outgoing board member, who Alan didn't mention, and that's Alan himself. Alan has served and led this board with distinction. His commitment is obvious, if only by looking at my calendar and seeing that Alan and I talk at least 4 or 5 times a week. Alan has served as a trustee, a vice chair, and now chair. He's led the board through this difficult and unprecedented year, and for that, I know that he has the thanks and respect of all of his colleagues on the board. With that, I would ask if there is a motion on the resolutions contained in this agenda item.
So moved.
Second.
Alan, I'd like to speak to this item.
Sure.
So I want to start by saying a few words about Alan, who was our outgoing chair. We have served on the board together now for 4 years, and he and I worked very closely together for the last 2 years. First as co-chairs of RAD, and this last year as chair and vice chair of the board. You know, I really don't know where to start in describing Alan's service to the bar and his good character as a person. I'm going to try, but there's so much to say about both that it's a real challenge. To start with, Alan has been absolutely tireless in carrying out his duties, both as RAD co-chair and chair. He always puts the State Bar first, and he is always thinking about how this organization can better serve the people of California. Let me just give you one example. When we were co-chairs of RAD, Alan took the initiative for the two of us to have regular meetings with Melanie and Steve to learn more about the workings of OCTC, which is a very complicated office, to meet with OCTC staff, to learn about the work they do on a daily basis, and to have a hands-on demonstration of the Odyssey system. He really wanted to dig in and contribute to RAD and to the oversight of the State Bar in a truly meaningful way, going above and beyond what has been typical for that role in the past. And in addition to all of that, Alan is always has a steady hand, has good judgment, and is a really solid leader. He's been open and thoughtful to new ideas and has contributed to innovation at the State Bar. But in addition to all of that, in addition to being a tireless and a wise leader, Alan is always very kind and always the gentleman. Whenever he had to point out something I had missed or expressed a different point of view or just pointing out that I had something totally wrong, he did it so deftly and graciously that it felt like he was paying me a compliment. That is the kind of person Alan is. So Alan, it really has been a pleasure to work with you these several years. And on behalf of the Board of Trustees, thank you. We will miss your sage observations and good fellowship. You have earned some, we are going to miss you, but you have earned some time off. Let me comment also briefly about our two outgoing board members. I join Donna in hoping Renee is not totally going to leave us soon, and we'll have her around for a little bit. It's always a joy to see Renee, talk to her. She has been our financial guru and protector on the board of the bar's finances. She brings a lot of wisdom and experience about good management and business practices to our board, and we have really benefited from that. And as one example, she has helped sensitize the more verbose among us to pare down our comments and not repeat what others have said, and that has contributed to our meetings being more informative and substantive. And Debbie, who recently decided to step down from the board and focus on her retirement, which is well earned after many decades of service in the state government. I had an opportunity to get to know Debbie pretty well when we worked together on the Legal Services Trust Fund Working Group, which was a really intense effort to look at that area of our operations. Both there and on the board in general, I really appreciated Debbie's voice and perspective. You know, like Alan, she has been tireless and she has worked extraordinarily hard as a board member, going way above and beyond the ordinary time commitment and commitment of energy that we expect from board members. So she was a real star, and we are going to miss her both professionally and personally, but wish her all the best in her retirement. She has earned the time with the family that she wants and needs now. And we hope she enjoys that, and we hope she'll come back and visit us sometime soon.
Well, thank you all very much for your kind words, Donna and Sean. I very much appreciate it. And you know my feelings. I really love being on this board and working with you all. So, and I must say that the only reason I didn't mention Renee's leaving is got my fingers crossed that she'll stay because she's such a valuable member of the board. So Renee, if you do leave, I wish you, all the best, but I'm got, like I say, my fingers crossed that you're not leaving anytime soon. So
it's under negotiation.
That's good. Also, we do have Arnie Sowell, who is a new board member, and actually he is replacing Debbie Manning, so he is a member of the board today. Arnie, I don't know if you'd like to, but if you are so inclined and would like to introduce yourself to the board, we would be delighted to have you speak to us.
Thank you so much, Mr. Chair. And I obviously have a lot to learn and don't want to take up too much time, but I look forward to working with everyone. I am, as you just mentioned, a very recent appointment. I think I took my oath of office either Monday or Tuesday of this week. I'm excited to sort of roll up my sleeves and get to work. I currently am the executive director of Next Gen Policy, which is a nonprofit organization that was started by Tom Steyer several years ago. We work on economic, environmental, and social/racial justice issues. So work in this area is clearly very sort of familiar to me. Also having spent a number of years, I won't comment as to how many in the state legislature, in particular in the state assembly and the speaker's office as a policy director to several speakers. And so really look forward to working with everyone. Mr. Chair, if I might, is there a possibility for me just to ask a question? I know I just took my first vote and I should have probably asked this of the staff before I did so, but it just occurred to me. And I wanted to make sure I just got something clarified. If that's okay, can I indulge the chair for just another paragraph or so?
I'm sorry, sure, go ahead.
When I just voted on the minutes from the meeting, I just wanted to make sure I'm voting on the minutes of the open meeting minute, not the closed session, correct? Because I'm unaware of what took place in closed session. And so I just wanted to make sure I clarified that.
No, those were the open minutes, the minutes of the open sessions of those two dates. We do the closed minutes separately.
All right, thank you so much. And thank you for indulging me in that regard. And once again, I really do look forward to working with everybody. It's an exciting time. I think we're at a very sort of momentous time and look forward to all the work ahead.
Welcome. Nice to have you aboard.
Thank you.
All right, let's go to, yes.
I believe we have a motion on the floor, and the only problem is I didn't capture the name. So can you please repeat who made the motion and who seconded it?
I moved the item.
I seconded.
So Saleg moved and Stallings seconded.
Okay. And for the record and for posterity, Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz,
Yes.
Dellen,
Yes.
Duran,
Chiming in with a bittersweet yes.
Iglesias,
Yes.
LeBron,
I guess, yes.
Pertula,
Yes.
Selig,
Yes.
Sowell,
Couldn't get to my unmute button fast enough. Yes.
okay, and Stallings.
Yes.
Okay, motion carries.
Well, thank you all again. I was holding my breath throughout the entire vote.
Probably pretty gut wrenching. I know you're all gonna be worried about this one.
All right. Now I think we're ready to move on to the consent agenda. There are numerous items on it. Does anyone wish to remove any items from the consent calendar? All right. Hearing no one, this again will require a motion and second to approve all of the items on the consent agenda. May I?
This is Duran. I'll second.
All right, Duran moved and De La Cruz seconded. Is there any further conversation, discussion? Madam Secretary, please take the roll.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz,
Yes.
Dellen,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Pertula,
Yes.
Selig,
Yes.
Sowell,
Yes.
Stallings.
Yes.
All of the consent items are moved into passed.
Thank you. All right, the next item on the agenda is item 100, reports of board committees. I'll begin on the executive committee. The executive committee met a few days ago to address one item, which turned out to be 50-2 on the consent agenda, was the approval of a specific contract pursuant to B&P Code Section 6008.6 for the interim chief financial officer, Kevin Harper, who has served in that role before. We did approve that, and of course, it's been approved by the committee. We're sorry that John Adams is leaving as the CFO. Haven't had a chance to talk to John, but we've certainly appreciated and all of your hard work, John. We wish you the best, and we hope that wherever your journey takes you, you are having a good time. But that's the only item that I have from executive committee. And thanks again, John.
Thank you.
All right, Brad, Brandon?
All right, so we just got done voting on the consent agenda. Several items that were discussed this morning and approved by the Regulation and Discipline Committee. And that was 54-121 through 54-123. And those two agenda items really reflect the hard work of RAD chair or co-chairs last year, as well as the hard work of Steve Moad and Melanie Lawrence, and then the State Bar Court, and everyone who collaborated with us on those rules. And so I just want to congratulate everyone on coming to the end of this. And further on in the Board of Trustees discussion, we'll talk more about the recommendations from Professor Robertson and what OCTC, RAD Vice Chair and Vice Chair and other staff have been working on to implement the will of the board. So thank you.
Thank you. Finance Committee, Renee?
Yeah. Hi. So let's see. So, and let me just say that this is my last act of anything official other than perhaps participating in a meeting. So, and I did look up, it's been 5.5 years. So sometimes, you know, you just gotta know when to go. But I did tell Donna that I would, depending how long the governor's office thought they would be, I would at least stay around to help. So, but today, actually, this is a good thing. The team, the finance team has been working really hard on this. John will walk through it in his last act as well. Always happy to have an opportunity to save a lot of money for the state bar. And I think this is a big plus from both financial and cash flow perspective. So I'm going to let, and it's fundamentally refinancing the San Francisco office. So I'm going to let John walk through this.
All right, thank you everyone. Good afternoon. It is just a couple minutes after noon, so that's a good thing as we proceed. So I'm going to go through, I have a few slides, and let's see if I can advance them. All right, there we go. So quickly, just want to do a quick intro on the members of the financing team. As you can see, as project lead, I work directly with the team and the committee. Want to give a big shout out to Robert Ratana of General Counsel, who provided a tremendous amount of support as part of this project, and Justin Ewert from the Office of Finance. On the phone and a presenter today who has a few slides, Chris Lynch, who is with the law firm of Jones Hall, who is here in San Francisco, and he is the bond counsel on this transaction. The State Bar's municipal advisor is James Fabian, who is with Fieldman and Rollup. He's available for questions, but does not have a formal role in the presentation. And then lastly, the placement agent, which is Jeff Land of Brandis Tolman, who's also here in the Bay Area. So just quickly, want to give a little background, give perspective to the board. As you know, and this really goes back 12 months ago, as the fee bill was approved, the State Bar did identify capital needs for the State Bar for both the San Francisco and LA buildings. As part of that request, ultimately what was recommended by the state auditor and ultimately approved by the legislature was less than what the State Bar requested. The state auditor did support the capital plan, the 5-year capital plan. The fee bill ultimately, even though it approved a 5-year capital plan and provided funding, at least recommendations for funding, that funding was not funded as the need arose, meaning in 2020, in which we had several $1 million of projects, what the legislature approved was the capital funding as part of the fee bill spread over a 10-year period. And as part of the budget approval that came to the board in January, knowing that we had this financial challenge as far as how we are going to fund the capital plan with only $800,000 a year for the next 10 years versus several million that needed to be used in the first year, the board, in adoption of that budget, gave direction to staff to put together comprehensive analysis on both not just the capital plan, but how we would fund that capital plan going forward. In February of 2020, staff did significant analysis. Steve Mazer, who is your Chief Administrative Officer, will be providing a presentation after this one related to that analysis and that update for the board. But Steve spent a lot of time doing that analysis based on direction, myself and him based on that direction. In March, and this is, I want to highlight, this was pre-COVID, and I don't want to say pre-COVID because COVID was certainly out there prior, but before the shelter in place and sort of the way that the environment had changed. His presentation talked about the State Bar reducing our footprint here in San Francisco, leasing additional floors, and what type of revenue could be certainly generated from that. COVID did significantly change that. And in May, based on COVID, as all of that analysis now, not to say was not useful, but it had changed because of COVID, there was one opportunity, and that was to refinance our long-term debt, and specifically the 2012 loan based on rates and certainly where the market was and how the Federal Reserve reduced the Fed's fund rate to zero. We provided that update to the committee. They directed us to provide a plan and to return to the committee in July. At the July Finance Committee meeting, we provided the plan, got direction from the committee. They provided significant value and feedback to really help us proceed with that, and that was in July. And then in September, in an 8-week period, we were able to assemble the team of experts to assist us, be able to put together the legal documents, was able to solicit term sheets from almost 8 banks after requesting term sheets from over 20. And based on that approval in September and recommendation, we're here today to get the board to approve the Finance Committee's recommendation to proceed with the loan refinancing for the 2012 loan. So just a summary on the 2012 loan. This was used to purchase the LA building back in 2012. This was a traditional commercial real estate loan, tax exempt, meaning the interest and earnings for the bank were exempt from federal taxes. The original loan was $25.5 million. The purchase was about $50 million, so about half of it was borrowed. Currently, the estimated balance, or the current outstanding, is about $14.2 million. It would be paid off towards the end of 2027. The current interest rate is 4.26%, and it's can be paid off now at par, so no prepayment penalty or no additional premiums for the payment. What's unusual is Renee talked about the San Francisco building was the collateral for that loan. This was the 2012 transaction was complex. It had several parties, and so at that time it was the security. It was a deed of trust on the San Francisco bill that was its security. Debt service about $2.3 million. And finally, I think a big point I want to make is there was a reserve requirement of $4.6 million equal to 2 years. So in addition to having the deed of trust on the San Francisco building, there was also a reserve of $4.6 million with Bank of America. So the financing plan is very easy. Take advantage of the current low rates and hopefully reduce those close to half. And there was an opportunity from a cash flow side, as Renee said, that we could, based on a tax-exempt municipal financing, maybe extend the term. So part of the discussion with the Finance Committee was, let's get proposals for the range. Let's ask for 10, 15, and 20 years. And that's exactly what we did. And this is a traditional, it's public agencies, government entities have various tools in the toolbox in borrowing money. After a consultation with the financing team, decided to tax-exempt municipal leasing financing. This was a private placement, but we did do a competitive process requesting proposals or term sheets from various banks. We did receive those in September, made quick work of the analysis, and then went to the Finance Committee for their recommendation on September 8th. And then this is with one lender. We talk about revenue bonds and we talk about bond counsel. This was really restricted to what we would consider more sophisticated or institutional investors. So you're not going to be selling bonds to a family trust as an example. So I'm going to turn over to Chris Lynch. Chris, I hope that you have the ability to talk. Chris was bond counsel, was key in putting these documents together. I want him to go through them. If there's questions for the board on any of the documents, I would encourage that as Chris goes through. Chris?
Good afternoon. Can everybody hear me?
Yes, I can.
Good afternoon, Mr. Chair, members of the board. As John explained, the proposed refinancing has been structured as a lease financing. Lease financings are very common for public agencies in California, particularly cities, counties, and school districts that cannot incur debt without a 2/3 vote. Because California's courts have recognized that leases with certain key characteristics are not debt. The financing team recommended that the financing be structured as a lease, as opposed to the loan and deed of trust structure that was used with Bank of America in 2012 and 2016, because the pool of likely lenders is comfortable with lease financings, and because it eliminates for the state bar the risk of acceleration and foreclosure in the event of a default. I'll discuss the possible remedies in a moment. There are 3 documents involved in the lease structure, and there's also 3 key participants: the state bar, the lender, and a 3rd participant, which is the Public Property Financing Corporation of California. That entity is a nonprofit corporation that, for a nominal fee, acts as the lease counterparty on municipal lease transactions. So under the site lease between the state bar and that corporation, the state bar will lease the Los Angeles office building and the underlying real property to the corporation. Under the lease agreement, the corporation will sublease the Los Angeles property to the state bar, and the state bar will agree to pay lease payments in an amount equal to debt service for the financing. The lease agreement is the key financing document, and I'll summarize some of its provisions in a moment. Under the assignment agreement, the corporation will assign its right under the lease agreement to the lender, including the right to receive the lease payments. The slide also lists a cost of issuance custodian agreement, but that's really an ancillary closing document under which the lender will wire a portion of the proceeds to a trustee bank who will use the proceeds to pay cost of issuance. Next slide. So Mr. Adams asked me to summarize some of the key terms of the lease agreement. The lease agreement requires the state bar to make quarterly lease payments to the lender as assignee of the corporation. The lease payments include a principal component and an interest component. The interest component is exempt from California personal income taxes, and it's excluded from gross income for federal income tax purposes. Our firm will give an opinion as to the tax-exempt status of interest to the state bar at closing. Because of the nature of the Los Angeles building, where the ground floor is leased to Smart & Final and the upper floors are also capable of sublease, staff emphasized that it was important to preserve the ability for the state bar to sublease the Los Angeles office building, which the lease agreement does preserve. Any sublease only requires an opinion of bond counsel that the lease will not adversely affect the federal tax law compliance. In addition, because the value of the Los Angeles building is significantly greater than the amount financed in this transaction, staff asked us to include in the lease agreement a right to leverage the value of the property for additional lease financings. The proposed lender here, Sterling Bank, has agreed in theory, but has reserved the right to consent to any specific transaction and has limited the amount of the additional financing to 40% of the fair market value of the Los Angeles property. Finally, with respect to the remedies that would be available to the lender if the state bar defaults under the lease agreement preserves for the lender any remedies available under law. Acceleration is not an available option, which is different from the traditional commercial loan structures that the state bar used in 2012 and 2016. In municipal financings, the most common remedy is for the lender to sue the municipal on an annual basis for payments that are due but not paid. However, sometimes lenders exercise the right to enter and release the premises and apply the payments that they receive to pay the state bar's scheduled lease payments. I'm available to answer any questions. Otherwise, I'll hand back the presentation to John.
All right, not seeing any. Let me talk just about the term sheets that we did get from multiple banks. And what I'm showing you here are the really, we received, as I said, term sheets for 10, 15, and 20. These are the best identified for each of those categories. I actually showed 2 for 10 years, and part of it was to show a comparison related to a callable versus a non-callable. The one that we selected was the 15-year. And you can see, you know, as far as the par amount, what the interest rate is, and very similar. what's interesting on the 10, 15, and 20 years, when you look at all of those, the interest rates are within a few basis points. So it wasn't as if there was a huge difference between each of the different terms. And you know, looking at the annual payments, the 15-year provides sort of the balance between savings and then also savings on an annual basis from cash flow. As I mentioned earlier, 2.3 million is now going to be 1.1 million, so close to $1.2 million in cash flow relief going into next year, which certainly is critical based on some revenues like interest earnings that have declined for the state bar. Net present value savings is just about 6%. Certainly when you compare that to the 10-year, you got 6.11. You're very close. All of these structures would have provided you know, savings for the state bar. And then I want to make a comment about the Bank of America loan. We did reach out to Bank of America. They have been an amazing partner for the state bar, provided options back in 2016 and 2012. Very supportive. We've had a lot of discussions with them. We did look and do analysis on their offer as well, in which I show you that here. Because we're dealing with their commercial real estate group, they have some limitations. And so, you know, related to the debt service, that's not something they were gonna not have. And then the security would have been very similar to what they had from 2012. Even with their best proposal based on current rates, you know, certainly a shorter term, but the net present, I mean, we're almost doubling the net present value with the new term with Sterling Bank. With that said, Finance Committee, after a lot of discussion, a lot going back and forth and giving them various options, they believe, and certainly staff recommended this to them, is that the 15-year term sheet provides the best balance between savings and providing cash flow relief. Interest rate is 2.3%. One of the highlights is the no reserve requirement, which we cash funded back in 2012. I won't go into the details. You know, we'll refinance it for the exact amount that's outstanding, not borrowing any new money. As Chris said, we have the options of doing borrowing if we need to in the future. There's no reserve fund, so that 4.6 million will return to the state bar. And one of the things I didn't really talk about, but is required by government code, is that the state bar adopt a debt management policy that was drafted, presented to the Finance Committee, and is in front of the board as well for approval as part of the resolution. So we're at the real tail end of this. Today's the board approval. You know, we really started on this project as far as putting things together in July, and the closing is scheduled for October 13th. And at that point, the Bank of America loan will be paid off, documents will be recorded, and ultimately that 4.6 million will be returned to the state bar shortly thereafter. And so in front of you today is the resolution one to proceed with the refinancing as outlined in the staff report, to approve the resolution that gives the authority to execute the various documents and signatories for those documents, and then to adopt a debt management policy. So sorry for the long presentation. You know, in general, this is a complex transaction, but I want to make sure that Chris and I provided you a full presentation for your benefit. So I'm available, and Chris is available for any questions. And I don't know if you want to have any comments, Renee.
No, you know, again, thank you for the work on this. I know this seems like a short timeline, but it's been worked on. It kind of fell in between board meetings. So I think we should see if there's a motion to approve the resolutions, and then we can see if there's any discussion.
Renee, this is Jose. I'll make the motion to approve.
Chair, excuse me, this is Secretary. Because this is coming from the board committee, it need not have a motion brought or a second. We can proceed straight to the vote when you're finished with the discussion.
Oh, very good. Well, is there any discussion, questions?
Renee, this is Josh. I just have a really quick question. Obviously, we started the endeavor in the middle of COVID, and I'm just curious what effect the consultants thought that had on the terms. they seem pretty favorable to me, but I'm just curious on how the market changed between, February or January, February versus July when we went out to the market.
I'm looking for Jim Fabian. Is he on as a presenter? Well, Josh,
There's no one with I searched under FAB. I see no Fabian.
Okay. Josh, let me, certainly we had done some preliminary analysis back in January, which, rates were better. They certainly weren't as good as they were after COVID. And I think when we were looking at it, it wouldn't have been a driving force back in January to do a straight refinancing. The thought process back then was a refinancing might provide the opportunity to borrow new money to do sort of the improvements, the tenant improvements or some other improvements at the San Francisco building. The reason why that's not being refinanced now is because we're not sure what to do with the San Francisco building as far as the lease spaces. But if I recall, Josh, and I'm gonna, ballpark this, I think the difference was 60 to 80 basis points. I know, Renee, we had talked before, and I think we were looking at what 300 or 3% was what we had initially thought prior to COVID. I think that's about the number I recall.
Yeah, I don't recall, but I don't remember twos.
Yes.
And John, I'm being told that Brandis Tallman has Jim Fabian with him. Shall I open his mic?
Yes, that'd be great.
Okay.
Yes, hello. Can everyone hear me?
Yes.
Yes.
So my name is Jeff Land. I'm with the firm Brandis Tallman. We served as the placement agent on this transaction. So we were the ones that administered the lender RFP on behalf of the State Bar. And we were very excited about the results of that lender RFP, getting something, in the low twos, under 2.5%. The market, as far as municipals go, went through quite an evolution, where rates definitely spiked in the spring, and then they have come down dramatically over the summer and really stabilized now. So we're actually hitting a great part of the market right now when it comes to something like this, which is a public finance transaction that's tax exempt. So there's actually a good amount of demand for tax exempt paper out there in both the public bond market and with the direct placement market that we worked in.
Thank you, Jeff.
So Josh,
thanks. It does. Thank you, Renee.
Yeah, just as Jeff, the summary is the timing, timing's everything, and just this, I don't think we could have had better timing on this transaction.
And how often do we get to say that?
Yeah.
Ruben.
Thanks, Renee. And I apologize if I missed this from John's presentation or from Mr. Lynch's, but I'm assuming the cost of issuance for this financing are paid out of the proceeds?
Yes, and cost of issuance, yes. So there's about 125,000 in cost of proceeds that are part of the transaction and will be part of the borrowing. So right now, let me step back. So right now we owe about 14.2 million. We will make one more debt service payment on October 1. The balance will be around 14 plus the cost of issuance, which gives us up to that about 4.2 again. So cost of issuance, I don't have the number directly in front of me, but it's about 125,000 between bond counsel, municipal advisor, placement agent, the non-corp rank that we talked about earlier, some trustee fees and stuff like that. So.
Other questions? Sonia?
First, I just really would like to express my gratitude to and appreciation of Renee's leadership and guidance in the Finance Committee. Learned a lot from you, and so very thankful and really hoping you'll still be with us for this year. Chair, LeBron and Alan, I need to recuse from the voting as an officer of one of the major institutions involved in this. I will need to, as I have done in the Finance Committee, to recuse from voting. Thank you.
No problem. Any other questions? Not sure if there's, I guess you have to check. I'm sorry, I got to check all these screens here. Good. All right. Well, I think seeing no other questions, may we have a vote, please?
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz,
Yes.
Dellen is recused, Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Bertula,
Yes.
Peleg,
Yes.
Sowell,
Yes.
Stallings.
Yes.
Motion carries.
Thank you. Yay. Anything else, Renee?
Nope, that's it. Thank you.
All right. Move on to Audit Committee. Josh, anything you'd like to report from the Audit Committee?
Thank you, Chair. No, I'll just be very brief. Instead of a report, I'm just going to give a quick 3 items that the Audit Committee is working on. I'm not going to dig into them, but the annual financial audit will begin again this fall. The IT assessment and business continuity is ongoing audit, and then it's that time again. So it's beginning our 2-year audit by the state auditor, and that item will come up before the board in May of 2021. That's my update. Thanks.
Any questions for Josh? All right, thanks very much. We're about ready to go into our agenda items under number 700. We've been going almost 2 hours, just shy. I propose that we take a 15-minute break to grab a quick lunch or whatever else anybody might need to do. Would anybody like to have that time extended, or is 15 minutes okay?
I was going to say that in making his comments about you, Mr. Chair, Mr. Saleg did not say that you were generous with your time.
All right, 15 minutes. So it being 12:28, let's see, 12:30. Let's come back at 12:45. Excuse me, is that right? 12:45 already? Yeah, 12:45.
Giving us the extra minute, thanks.
Yeah.
Yeah.
Don't waste it.
Alan still runs a tight ship.
Not for long. Glad to see you made it back on time, Mr. Duran.
I am dutiful, if nothing else.
Okay. It being 12:45, we can go ahead and start. We're reconvened for the continuation of the State Bar Board of Trustees meeting. Our next agenda item is 701, a real estate analysis and strategy development update from Steve Mazer. And Steve, I saw you lurking there, so take it away, sir.
Okay, good afternoon. So this is a brief status update about the real estate strategy and analysis related to 180 Howard Street, and in particular, the impact that the pandemic has had on this initiative. I'm showing on this slide here the points that I plan to cover briefly. This item is informational, does not require specific action on the part of the board, but it is teeing up a discussion and likely guidance that the board will want to give us. So by way of background, and John mentioned this, these discussions regarding the economics of owning 180 Howard Street have been going on this entire year. They were part of the 2020 budget planning process with the full board, and there have been ongoing discussions with the Finance Committee throughout the year. As we recall, and as John mentioned, we do have some challenges. The building does require capital improvements, and the 10-year equal installment funding that we received to do those improvements does not really align with the actual schedule we would need to use, and so does not really allow the program to be implemented as envisioned at this moment. Additionally, funding is not available for renovation and leasing costs related to tenant floors. So related to all of this, the questions that we have been asking, specifically with the Finance Committee, can we get more value from this building, specifically by leasing the one remaining vacant floor and potentially reducing the State Bar's footprint to make additional space available for leasing? We've also been asking, can we afford to own this building long-term? To answer that question, the plan has been to have our real estate partners perform various occupancy, an analysis of various occupancy options, including retaining ownership, selling the building and leasing back, or selling and relocating elsewhere, either as a tenant or as an owner of a smaller building. So that is by way of background. Quickly, just an update about the leasing situation currently for 2020. There has been a modest impact on rent revenue from the COVID-19 situation. Everything is very stable with our office tenants. They are all paid in full. We do have some of our smaller retail tenants that have been closed or doing very limited business. We've implemented some rent discounts or deferrals to keep those tenants viable in line with current industry practices. So the net impact is about a modest 5% reduction in the expected rent revenue for this calendar year. In terms of actual numbers, that's about $180,000 reduction out of a budgeted $3.8 million in rental income. For 2021, there is a more significant impact on the leasing market overall. There is a decreasing demand for space for reasons I'm sure we can all understand. There is an increasing supply of space, especially in the subleasing market. Our real estate partners have advised us there's about 6.5 million square feet of sublease space now available, which is a new record for San Francisco. And a particularly interesting point of information, there's about 250,000 square feet of sublease space hitting the market every week. For point of reference, our building is 208,000 square feet. So there's the equivalent of 180 Howard Street coming on the sublease market every week. Additionally, as a result of all of this extra space coming on the market, leasing rates are likely to drop. All of this is going to make it potentially more difficult to lease our one remaining unrenovated vacant floor in this building. And office tenant renewals and retail tenant viability looking ahead to 2021 is still to be determined. Thinking about the question of getting more value from the building, specifically for the possibility of reducing the State Bar's space, at the beginning of this year, at the very beginning, we completed a workplace strategy analysis with our real estate partner, Cushman & Wakefield. That study did show us that we could consolidate State Bar operations and make more space available for leasing. Potentially, we could release 1 or even 2 full floors. There is a very, very significant cost to doing that, both to reconfigure the space in which the State Bar would remain and to renovate new tenant floors. And of course, important to note, this space and usage analysis was all based on pre-COVID assumptions. Looking at now the preliminary valuation and occupancy analysis, we did a detailed occupancy analysis was originally planned for the early part of this year with Cushman & Wakefield's Capital Markets Group, including all of the various occupancy scenarios related to either keeping or selling the building. However, the pandemic has caused uncertainty in all sectors of the real estate market, as it has throughout the economy. So a lot of the assumptions they were going to make are no longer valid. So because of this, that exercise was not completed, realizing we need time for markets to settle down and for the bar to make some other decisions that it needs to make for itself. They did, however, do a very preliminary, very high-level analysis of the building valuation, which is interesting to look at. So from this table here, you can see immediately pre-COVID, the estimated building value of 180 Howard Street was about $215 million. That's up from the last estimate we did in early 2019. Immediately post-COVID, however, there's an estimated 20% drop with a value of about $172 million. Cushman & Wakefield does report Debt markets are improving. There is money available for financing. Investors are betting on a future recovery. And of course, our building is in a very desirable location. So we definitely could sell the building for a good price if we chose to. A scenario where we sell and vacate would generate the most interest in the market, according to our real estate partners. Additionally, the same economic factors that make our building a little less valuable today than it was before and that are making lease rates drop could also potentially work to our advantage if we choose to sell and purchase a smaller building or lease space instead of owning. Now, to move forward with a more meaningful analysis and a cost-benefit analysis of keeping the building versus selling and either purchasing or leasing, our real estate team would need to do the full economic analysis of all scenarios that was originally envisioned using up-to-date market conditions. A challenge, however, with that is the issue of State Bar figuring out our actual space needs. I'm sure it's no surprise to hear it is very difficult to move forward with an analysis of occupancy scenarios until the bar actually determines its actual future space need in a post-COVID world. Whether we will need to keep 120,000 square feet as we have now, or drop to 80,000 or 60,000 or some other number, obviously impacts the decisions that we need to make about what we're going to do with this building. Just to provide a few points of information, the original space assumptions in the workplace strategy study, those were pre-COVID, as I said, and those assumptions included that all employees are in the office every day, that there is a dedicated seat for each person, and that were we to reduce our space, that is accomplished by creating a significant increase in the density per floor. During COVID now, and especially since our return to normal operations around June, approximately 50% of our staff remain telecommuting full-time. The other half are in the office somewhere between 1 and 5 days a week. And on any given day, we're having about 20% of staff in the office. Looking ahead to post-COVID, the nature of the workplace is just not yet very clear. Things we would need to figure out: the number of employees that will be in the office on any given day. Will we have dedicated workspace as we have now versus a hoteling model of shared workspace? Will there be ongoing health issues such that the number of seats and the footprint per seat may need to be larger than originally anticipated if physical distancing in some form remains a long-term consideration? So the leadership team, Donna and the chiefs, have started thinking about this, trying to envision what that post-COVID workplace is going to look like. We're assessing our operations since June, since the return to normal operations, to see how telecommuting and other factors on this scale have been working out. We are surveying our staff to get their take on what is working, what's not working, what their hopes are for the future. We're looking at industry sources. Needless to say, there's a lot being written about this topic in the real estate industry and across the board in the work world. So that is a quick update of where we are. Again, there's no specific action being requested of the board, but this is teeing up for a discussion and potentially some additional guidance from the board about where we go from here.
Steve, thank you very much. It was a very fine presentation. Are there any questions from any of the board members for Steve? All right. I guess not, Steve. You blew them away.
Okay. We have plenty to do, so.
Yeah, you do. Okay. All right. Thanks very much. Then we will go on to item 702, closing the Justice Gap Working Group and appointment of members. And for that, we have Randall D. Furtorm, the Program Director of the Office of Professional Competence. Randall.
Good morning, members of the board. Randall D. Furtorm, Office of Professional Competence. Agenda item 702 presents a staff recommendation for the appointment of the members of the Closing the Justice Gap Working Group, including officers and alternates. The Board of Trustees formed the working group in response to the report and recommendation of the Task Force on Access Through Innovation of Legal Services, which we refer to as ADLS. ADLS was assigned to develop recommendations for regulatory changes to enhance the delivery of and access to legal services through the use of technology, including artificial intelligence, innovative online legal service delivery models, and other systems. The ADLS report was received by the board at its March meeting and discussed at both the March and May meetings. The board's work on some of the ADLS recommendations has already been completed. Previously, the board considered the regulatory principles that ADLS studied concerning the licensing of non-lawyer paraprofessionals to deliver legal services, and that was forwarded to the State Bar's dedicated working group on a paraprofessional program. The board has also already addressed 2 rule of professional conduct proposals by ADLS, including the proposal that was just adopted this morning, and earlier a proposal to amend the competence rule to provide that the duty of competence includes competence in technology used in the practice of law. So those 2 rules will be on their way to the Supreme Court and will wrap up those recommendations of ADLS. Others ADLS recommendations, however, remain in play, and the Closing the Justice Gap Working Group has the assignment to continue the good work on those recommendations. The charter for the working group is posted with the agenda materials as attachment A, and it's summarized in the agenda item. In short, the working group is charged with 1, exploring the development of a regulatory sandbox, 2, considering further amendments to Rule 5.4, which addresses fee sharing with non-lawyers, 3, issuing for public comment a new rule addressing the delivery of non-legal services provided by lawyers or businesses owned or affiliated with lawyers in the ABA model rules. That would be Rule 5.7, a rule that we've never had in California. Number 4, considering recommendations for amendments to the Certified Lawyer Referral Service statutes and rules of the State Bar. And 5, considering recommendations for amendments to the rules governing advertising and solicitation. At the last board meeting, the charter, as well as the desired composition of the task force, was discussed. And the subject matter expertise, as well as stakeholder representation, is listed on pages 2 and 3 of the agenda item. That list includes categories such as technology expert, legal ethics expert, economist, regulator, consumer legal services. The application and nomination period began on August 21st, and nearly 100 applications were received following outreach activities that included a social media campaign that targeted consumers of legal services. In addition, specific nominations were sought from and submitted by the California Lawyers Association, the Consumer Attorneys of California, the California Defense Council, and the Utah Regulatory Reform Task Force. Staff reviewed the applications and nominations with a focus on the board's composition objectives, as well as the overarching State Bar diversity goals, and staff's recommended slate for members, officers, and alternates is provided as attachment B. In conducting this exercise, staff recognized that the working group chair should be able to designate subcommittees with subcommittee officers, appoint additional advisory members to strategically add knowledge and expertise, such as the appointment of consumer focus groups. And also staff recognize that it's anticipated that a Supreme Court liaison will be attending the working group's meetings, similar to the role played on the ADLS task force. At this point, risk of moving too fast, I want to jump ahead, and if we can project the resolution language, because I just want to walk you through how the staff recommendation is structured.
Just give me a moment, Randy.
Sure. So the resolution begins with a delegation. If you've read the agenda item, you know that while we have come up with a slate of recommended appointees, we are one short in terms of the chair of the working group. And so the resolution, the first part of it, asks the board to authorize the chair of the board to appoint the chair of the Closing the Justice Gap Working Group Outreach will continue, and we are endeavoring to find a judicial officer to serve in that role as that key leadership position. We hope to be able to continue that outreach and provide a candidate for the board chair's appointment as soon as possible. With that delegated appointment, the resolution offers the slate of candidates recommended by staff, which is the first further resolve, and includes the other officers of the task force, the proposed co-vice chairs, as well as the actual task force members. The next further resolve in the agenda item indicates that we do want to have the standard procedure where alternates are recommended and appointed in the event that there's someone who vacates their position or outright declines the appointment when it is sent to them. But because we have endeavored to have specific slots, if you will, for subject matter expertise or representation, the actual designation of alternates is not just a single list top to bottom, take the next one from the top of the list. But if you look to the list of alternates, attachment B, you'll see that we've set it up in a table so that if, for example, it is the seat for the economist that is vacated, that the board's alternate is someone with like expertise. The appointment process, again, also involved reaching out to specific stakeholder groups. And for those vacancies, should they occur, rather than having any alternate on the selection list, the resolution asks that the board authorize the chair of the working group to interface to solicit from the specific stakeholder group a replacement. And so if, for example, the California Lawyers Association nominee were to resign, then the chair of the working group would ask that group to nominate a replacement. The last resolution authorizes the chair of the working group to appoint additional non-voting advisors, including not limited to focus groups. And we just wanted to make that explicit in terms of the ability of the working group to add expertise as needed, particularly in the area of consumer input through these focus groups or other ancillary advisory bodies. And I want to return to the body of the agenda item and walk you through the selections that have been made. But I want to stop here first and ask if there's any questions about the resolution in terms of what is being recommended. Okay. If you look at starting at page 3, we have the recommendation of the officers.
I think, Randy, I think Mark was waving.
Yeah, I had a question.
Oh, please.
Yeah, I'm just curious as to why we have not found a chair yet, and why, at least in the body of the agenda item, it talks about trying to identify a judicial officer to take that position. It somewhat limits us. The other thing is, if we don't have a chair, I don't know how we can vote to approve the chair having authority. So maybe it would be good to have, to give the co-vice chairs that authority if we don't have a chair.
Well, we will have a chair. I'm pretty sure we will have a chair at some point. And the goal of reaching out to a judicial officer in part is based on my own personal experience with the ADLS task force, that the judicial temperament is precisely what is needed for this type of volunteer body. We had great success and benefit with the Honorable Lee Edmonds serving as the chair of that group. And it would be great if we could find someone very similar to her to serve as the chair of this group. In addition, the list of expertise, the desired composition includes a judicial officer, and that was the weakest category in the applicant pool. We did not have judicial officers applying to serve on the task force. And so if we want to meet that composition goal, I can't think of a better place for that than at the helm and leadership role. But if we can't, I don't think there's anything in this, it's definitely not in the resolution that would lock in the chair of the board to appointing a person who's not a judicial officer.
Yeah, Mark, just I think to clarify terms, you had suggested how can the chair of the working group appoint? I think I'm not sure it's clear the chair of the board is the one who will pick the chair of the working group, even though he's a disreputable character.
That is true.
The original timeline for the working group was to attempt to have an orientation first meeting in November, and the delegation to the chair of the board would give us the flexibility to maybe stay on that timeline. If we could find that person willing to serve, qualified to serve, and they were appointed by the chair of the board, then we could set that meeting and get to work.
Tonya?
I also would like to find out how it is that we don't have any Asian American Pacific Islander representation on the list, the roster. I would wish that we would have a voting AAPI member of the roster, as well as direct consumers, as have been mentioned earlier.
We do have as part of the agenda item the diversity factors of the slate recommended by staff. And we also have at attachment C, we do have the list of persons who were in the applicant pool but not selected. And so we can discuss any of those other persons as possible appointees. In particular, in response to the commentary by the oral public comment at the start of the meeting with regard to consumers of legal services, there are folks in the attachment C who check the box consumers of legal services in their application. And I'm also prepared to talk about any of those folks if the persons in the body of the agenda item who are recommended are not acceptable to the board. So again, this is a staff recommendation, but you're making the appointments. So going back to the
Yes, Arnie, excuse me, Randall. Paul has a question.
Sure.
Thank you so much, and I appreciate the timeliness of this agenda item. If I understand it correctly, in terms of attempting to try to address the issue of digital access to legal services, I want to make this comment and ask this question. If there's anything that the pandemic has shown us, it is that there is an equity issue and a digital divide issue at this time. And I just wanted to make sure, either in looking at the resolution and looking at the agenda item, I think I saw an attempt, to ensure that there's access to folks at all income levels, et cetera, et cetera. And whether in the focus groups or on the committee itself, the working group itself, it seemed like we should have some experts or a focus group on digital inclusion, folks from that area that have been working on these types of issues and trying to ensure that digital access gets into to low-income communities of color all across the state. And so I'm just wondering whether or not we have that representation, and if not, how we get that sort of representation on the working group.
We have in the slate of staff recommended appointees, 2 technology experts. One of them is David Engstrom. He's the Associate Dean at Stanford University for Strategic Initiatives on Law and Technology. And he's actually the chair of the law schools, and they call it their Beyond COVID Task Force, which is tasked with studying how the law school's programs can better serve current students and future lawyers. He's a lawyer with experience in machine learning and 2 decades of litigation experience. We're hoping that his expertise from Stanford on law and technology, in particular, with this focus on how COVID is affecting things, will be helpful in guiding the working group with regard to those aspects.
I appreciate that. I would just urge us to, you mentioned that there are some focus groups opportunities. I would urge us to think about having a specific focus group that's dedicated to this, to ensure the fact that this is a topic and an action item that is addressed in the most robust way.
I think we can do that.
And I would also add, as a reminder, we do have representatives from legal services organizations that represent low-income clients from communities that face that very digital divide that you're talking about, and they can also help bring that voice.
Thanks.
Okay, Randall.
The recommendation for the co-vice chairs include one of the recommended legal ethics experts. Mary Baldwin is a shareholder at Rogers Joseph. She has a practice that focuses on attorney ethics, encompasses ethics advising, counseling, litigation involving malpractice, breach of fiduciary duty, fee claims. She's a member of the CLA Legal Ethics Committee. She's a former chair of COPRAC. She does presentations on legal ethics. I think I've had the privilege more than once serving with her on MCLE panels on legal ethics. And she is our recommendation for one of the co-vice chairs. The other co-vice chair is Professor Rebecca Sandiford. She's a faculty fellow of the American Bar Foundation and Arizona State University, and she leads their Access to Justice Research Initiative. She has been working with the Utah group as well, and she made a very compelling presentation to the ADLS task force when it came to access through technological means. She would, among her other expertise, provide knowledge of the extensive academic scholarship on regulatory reform. So these would be our 2 co-vice chairs. And the strategy with this is that we have a lawyer in Mary Baldwin, who's a legal ethics expert, because in addition to what might be the marquee item on the charter, the sandbox, the other aspects of the charter for the task force are primarily legal ethics issues. Further amendments to Rule 5.4 concerning fee sharing, a new rule similar to the ABA's Model Rule 5.7 on non-legal services, revisiting the advertising and solicitation rules, as well as the certified lawyer referral service rules. So we think whoever is chairing the task force would be well served by having a legal ethics expert as one of the co-vice chairs. And Mary has also demonstrated her leadership for the State Bar as a chair of COPRAC. By having Professor Sandiford as a non-lawyer co-vice chair, we arm the leader, the chair of the task force, with someone who understands, again, the big spotlight issue, a regulatory sandbox. And that is a complex topic, and I wouldn't expect whoever we get as chair to be an expert on regulatory sandboxes or regulatory reform, either in the legal services realm or any other realm. But having Dr. Sandiford, Professor Sandiford, as the other right-hand person, staff makes sense. Moving on to the members of the task force. We have a recommendation for 2 technology experts. I've already mentioned David Engstrom from Stanford. The other technology person is Reem Alos, manager in the privacy practice with KPMG as a privacy consultant. She assists clients on compliance with data protection and the California Consumer Privacy Act. She has a bachelor's degree in computer science, as well as a master of science in software systems and engineering, and a JD.
Randy?
Hi.
Randy, before you continue, maybe we should check with the board. You've laid this out pretty clearly in the agenda item. I don't know if they need you to go through each of the individual members, and maybe we should ask the board if they have questions on any of the particular named recommended appointees, in which case that would be appropriate for you to walk through them.
I am absolutely fine with that.
Are there any questions on the composition of the, yes, Sean?
Well, I have a comment. I'm thinking in light of Sonia's comment in particular, and the fact that we don't have a chair ready to appoint, so the group is not ready to proceed immediately. I wonder if we should hold off approving this slate and give some consideration to the issue Sonia raised. One of the things I noticed, I hadn't noticed until Sonia raised this, is that there's some discussion of diversity factors with the people who are proposed for appointment, but not with the applicant pool. And in light of Sonia's comment, there's at least one candidate I would consider reaching out to specifically. So I wonder if we should not vote on this today, and then we can come back to the board with hopefully with a chair candidate, so the committee is ready to roll, and perhaps some slight, wouldn't expect radical revisions, but perhaps some slight changes to the composition of the group, and also how we're presenting the diversity factors, which I have some thoughts about. So I throw that out for comment.
Any comment from the board?
So if we were to approve this today, does that mean that limits the number of people that you can place on this group? In other words, Sean, I think you talked about the chair of the board being able to appoint the chair of the committee. And then the chair of the committee would be the one who can appoint additional people. So is it possible that we can approve them today and then add those other individuals as we see appropriate? I mean, I would hate to wait till December or whatever our next meeting is.
Yeah,
before we can get this going.
we could. It's already a very large committee as proposed. So that's my only thought is I wouldn't tie the hands. If you want to give it a fresh look, if the board wants to give it a fresh look, then I wouldn't tie the people's hands who are working on that. But certainly you could proceed as you suggest, Mark. And the other thing that we could do is we could either try to set a special meeting to cover this of the board, or we could delegate it to executive committee. And in the event that we are ready to proceed with this before the next regularly scheduled meeting in November.
Are there any comments on the various suggestions that Sean has made? One, kicking it over for review again in November, perhaps a special board meeting in between, or a delegation to the executive committee. Yes, Sonia.
I would, I think, vote for a special meeting immediately, not to be very long, give us a couple days or so, and then have a 10-day notice period, and then hold a special meeting.
Any other comments? Randall, did you, were you listening to the public comments that were provided? There was at least one speaker who addressed the composition of the board in terms of direct recipients of these anticipated services as opposed to people who are, if you will, in the business of providing services. And I don't want to get into a detailed discussion of that. I'm just curious as to whether you heard those comments.
Yes, and we did have a number of applicants who checked the box consumer of legal services. And it's pretty clear from the bios of the two candidates in the slate provided that we were not able to recommend to the board people who would be, as I think the one commenter put it, a small business person who would be a quote unquote true consumer of legal services. Instead, what we recommended were people who we believe espoused the voice of the consumer in terms of a disability rights advocate as one, and a person who is not a lawyer, but is a legal document assistant and real estate broker. But what we found with the ADLS task force, particularly when we held our town hall meeting in Sacramento, and even at other meetings where the legal document assistants came to us, there were leaders from the Legal Document Assistant Association in Sacramento. They are very much boots on the ground folks who are able to say what consumers of limited means are able to do in terms of, number one, finding alternatives to a lawyer or a law firm. Number two, how well are they able to achieve their goals for legal services or alternate services when they're not being served by a lawyer. So we did think that someone from the legal documents area would be helpful as a non-lawyer representative who could, again, espouse the consumer experience, as well as the other person that we've recommended, who is a disability rights advocate, as well as a long-term volunteer with an LSC state bar funded legal aid organization. One of the things that was brought to the attention of ADLS was that if we were considering allowing artificial intelligence technology online interfaces for delivering legal services chatbots, that we would have to keep a close eye on whether these things were truly accessible to one of the most in need groups, which is the disabled community. And so having him as a non-lawyer representative, although he holds a JD, was someone we felt was a viable pick. Now, what I will tell you about the rest of the applicant pool is that we did do a social media campaign, and we did get persons who described themselves, they checked the box as consumer of legal services, but several of them provided no resume, no bio, and no statement of interest, and had names that we could not even Google and determine whether or not their representation of consumer of legal services had solid credentials that we could hope would serve the working group well. Others who list themselves, and these are folks on attachment C, as consumers of legal services, included professors, other JDs, forensic criminal specialists. There are people who are similar to the people that we've actually selected, in that, again, they're not exactly the person on the street, the man or woman on the bus who might be a quote unquote true consumer of legal services. But I will mention that if the primary issue is looking for someone who is not in any sort of actual service or related area of service provider, not a market participant, if you will, to be a voting member of this working group, then I would call attention to, this is on the second page of attachment C, two of the applicants that were not selected, but I'll bring to your attention, Kathy Hong, who listed Consumer of Legal Services. She's the Senior Director of Data and Evaluation and Development for the YMCA of Metropolitan Los Angeles. And another person would be Sophie Sargsyan, also marked Consumer Legal Services. She is a library assistant with the Glendale Library, where she leads groups and individual instruction on technology topics such as adult computer literacy. I think if the board wanted to move away from anybody who might be any sort of service provider, even if they might be a disability rights advocates, or even if they might have other related service participation, a legal document system, then you could, for example, look at folks like the two that I just mentioned.
Okay, yeah, Randall, I mean, the board isn't going to be making personnel decisions this afternoon. So I think the only reason for drawing your attention to it is to make sure that you had heard the comments. And I certainly appreciate the difficulty of putting together a task force like this. You've got a lot of different perspectives that you want to bring on board, and a lot of different people who want to have their voices heard. So and you don't want the committee to get so big that it's unmanageable. So I
absolutely
understand that. But let's go back. And first of all, Donna, if we didn't move on this today, what is your timeline, and what time frame would you like to get this completed in?
So sort of a precise timeline. I have a little bit of reaching out to do. I'm going to take the blame on the chair and not having the chair just yet. I just talked to one justice who we were interested in having chair, and haven't had the opportunity to reach out to a couple of others. But we do have some names and some thoughts. So I'm hoping that we can fairly quickly, in light of everything else that's going on right now, line up the chair, and we can certainly go back through the roster that Randy had provided. Certainly, we are limited in listing the diversity factors to the diversity information that was provided by the applicants. So we may not have better information for you, but we will take a look at that. I think the easiest thing would probably be to plan to have an executive committee meeting come back in, roughly, I'd say the week after the bar exam, 3 weeks.
Yeah, I don't think you want to schedule anything between now and the bar exam.
I would say we should allow 4 weeks, because just to be practical, if we're going to do
why don't
more
we
rejiggering and possibly some outreach.
Yeah, why don't we do this, Sean? Why don't you propose a motion to delay the vote on this, the addressing of this issue? I'm not sure you need to put in a specific time period, but how you would propose handling it, be it executive committee, or the only other suggestion that did receive any board support was a special board meeting. And I think you could probably leave that open unless someone wanted to insist on the special board meeting, which would be fine. But then I don't think the board is ready to move on this today. So I think we ought to defer it. And I would entertain a motion to that effect, unless anyone has any disagreement. All right. Sean, you want to work on that alternate motion there?
Sure. I would say, well, first of all, let me ask, does any board member feel strongly about asking the executive committee to consider this in about a month as opposed to the full board? Just recognizing it's much easier to schedule the executive committee than the full board. So, but if people feel strongly about that, then we can try to convene the entire board.
Okay, so the executive committee, if nobody else chimes in.
Okay, all right. So then, so the alternate motion will be that the board elects not to take action on this item today, and asks the chair of the board, the new chair of the board, to consult further with staff about the issues raised at the meeting. And delegates to the executive committee authority to appoint or to act on this item prior to the next scheduled board meeting.
I'd second that motion, Mr. Chair.
All right, so the motion by Mr. Saleg, seconded by Mr. Duran. And my understanding is that the authority delegated to the executive committee to act on this item includes approving the a slate as presented today, including perhaps the chair and so forth. Is that correct?
Correct.
And is that, does your second still hold, Mr. Duran?
It does, yes.
All right. All right, is there any discussion on this motion? Hearing none, Ms. Secretary, please call the roll.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz,
Yes.
Dallin,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron.
She may be off.
Okay. Pertula,
Yes.
Selig,
Yes.
Sowell,
Yes.
Stallings.
Yes.
Alternate motion carries.
All right, thank you, everyone. While we're cleaning this up and moving on to the next agenda item, let me just say that we spent a little bit of time on this, but I think it's time well spent because that motion regarding the composition of the Justice Gap Task Force or Working Group or whatever, and the next item, which is the paraprofessional program that Chris is leading, I think are very, very important, and they are controversial, and it is important to get the composition of these groups right. And it's also going to take, I think, in the very near future, a firm commitment by the board to be open to what may be controversial proposals. I have no idea where the Justice Gap Working Group will go. It has the sandbox tool available to it, but we need to focus on and imagine how people in this state can be served and have their legal service needs met in ways that may differ somewhat from the way that we are doing it now. Maybe not, I don't know. I'm not trying to jump ahead of the committees, but these are really both very important issues, and I think that it is wise on our part to be cautious as we proceed so that we have the best possible committees and the best possible results. Having said that, Chris, item 703, the California Paraprofessional Program Working Group, status update.
Thanks, Mr. Chair. And again, Ellen, I want to thank you for your leadership. It's a pleasure working with you. I really appreciate it. I also want to thank Renee too for her leadership, and also Debbie Manning. She was she participated a lot in the working group and just kind of lent her leadership in a lot of these lengthy meetings. So I just want to thank Debbie and congratulate Sean and Ruben for taking over the helm during these challenging times, and welcome Arnie. So I have a quick prepared statement, and I'll get through it quickly. So as you know, there is a massive gap between the need for civil legal services and the availability of those services at a cost that people can afford. The California Justice Gap Study completed last year quantified that gap. 85% of the civil legal needs of all Californians, regardless of income, are unmet. And that was prior to the pandemic. And I think the needs in the pandemic, especially in low-income communities, are just through the roof right now. And I think it's only going to get worse. And it's something that I see every day, so I feel very confident in saying that, unfortunately. The board decided to move forward with the creation of a new class of licensed legal professional called the triple LTs in some states in an attempt to address this need. The California Paraprofessional Working Group, which I serve as the chair, is charged with developing the parameters of a California licensed paraprofessional program. The working group has been meeting since April. And I also want to thank the members of the working group. We have, I think, a good group, very committed and very smart group. The working group initially undertook to determine the areas of practice that would be included in a paraprofessional program, as well as the specific tasks that paraprofessionals would be allowed to engage in. The initial plan had been to move to a discussion of paths to licensure, education, testing, experience, etc., after the practice areas were selected. However, in the course of discussion about practice areas, it became clear that the working group members were not comfortable with authorizing paraprofessional practice in any but the most limited areas absent an understanding of licensing and regulatory requirements. As a result, the most recent meeting of the working group in August, it was decided that further discussion about practice areas would be suspended for the moment, and that the group would turn to the issues of licensure and regulation. Subcommittees have been formed to study these topics, as well as options for a disciplinary model, and will make preliminary recommendations to the working group at the next meeting scheduled for October 29th. In my view, a strong consumer voice is notably missing from the working group deliberations. The group is comprised of 11 lawyers and only 3 non-lawyers, one of which is a very recently appointed public member. Similarly, public comment is dominated by lawyers. Nothing against them or anything, but be they private practice or legal service attorneys, they're still lawyers. While I truly believe that concern these attorneys express about the risk of licensing non-lawyers to provide legal services should be seriously considered, I fear that the implicit solutions they offer to provide more funding for legal services and those who do not qualify for free legal services to simply hire lawyers will not result in any meaningful impact on the justice gap. We know from the justice gap study that we need about 9,000 more attorneys to meet the current need for IOLTA-funded legal services, and that the vast majority of Californians do not qualify for such services. We know from the study that barriers, including lack of knowledge that a problem is a legal one, and the cost of legal services prevent many, many Californians from accessing legal help. We must act, and we must do so in a meaningful way. I believe that currently and wisely licensing paraprofessionals can provide a source of much needed help to those who neither qualify for IOLTA-funded legal services, nor can come close to affording an attorney. Finally, we need to empower the public who stands to benefit from reform to have a real voice in our work. To that end, we are exploring options for bringing more consumer voices to the table. We recently engaged in a social media campaign from which we identified the consumer who was just appointed to the group. We are also going to be exploring gathering a consumer focus groups or bringing in consumers, and I may come back to you to request additional consumer seats on the working group. Thank you very much. Thanks, Alan.
Chris, thank you very much, and thank you for sharing this group. It's doing good work, and it's a difficult thing to get your arms around, and I know that. And thank you for all your time and effort on it and good leadership. Are there any questions for Chris? Okay. Well, all right. Thank you for that report, then, Chris. And as I say, I think this is going to be something that the board will be dealing with in the very near future. So thank you all. All right, let's go to item 704, the State Bar Discipline System, implementation of changes to address disparity and so forth. Lisa Chavez is presenting on this. And Lisa, hi.
Hi, good afternoon, everyone. As always, it's great to see everyone. My name is Lisa Chavez. I'm the director of ORIA, which is the Office of Research and Institutional Accountability. And I have a presentation to share with you, so I'm going to share my screen. Okay, do you see it? Do you see it?
Yes.
Okay, terrific. Okay, so this is agenda item 704. Long title, but it's the State Bar Discipline System. Implementation of changes to address disparity, past and planned changes to improve efficiency, process, and experience, and a recommendation for an ad hoc commission on the discipline system. The agenda item you received has these 4 big topics. Like I said, which are essentially in the title. I'm going to go ahead and switch the order of how it flows in the document, and instead I'm going to start with describing the breadth and depth of changes made by OCTC over the last decade. I'll touch on the discipline system research agenda that we are launching, and then I will move towards a discussion of the projects that flowed from the Robertson report that address disparities, and I'll conclude with talking about the ad hoc commission. So the reason why this memo includes a discussion of all the changes that OCTC has made over the last decade is because most of the recommendations that Professor Robertson makes really build upon the dozens of initiatives, policies, and procedures that the State Bar has implemented over the last several years. And as described in the background section of this agenda item, OCTC has undergone numerous major organizational changes, many in response to recommendations flowing from a 2015 audit report, as well as a 2016 workforce planning report. However, other changes have been made that have been initiated by OCTC leadership in their ongoing effort to streamline operations and ensure that the State Bar fulfills its public protection mandate. For example, case prioritization is one of the most important changes introduced in recent years, and that mandate was developed entirely by OCTC leadership. A detailed and comprehensive description of these changes is found in attachment B. Please note that the summary is not exhaustive, but instead that attachment focuses on the changes that involved organizational structuring to process cases more efficiently and effectively. And here's an example of the 3 types of big buckets of changes that you can see in that attachment B. Basically, they're changes that resulted in improvement in processes, efficiency, and public protection. The memo also describes a research agenda that my office has developed recently in partnership with OCTC. As much as I would love to talk to you about all these awesome research projects in development and that we're currently executing, I'm just going to leave it to you to read more about it in the memo. But 3 big topics that are guiding this research agenda are risk-based regulation, always the interest in improving efficiency and accountability, and of course, continued research on disparities. But let me get to what we're probably most excited about today, and that is an update on all of the research projects that flowed from the Robertson report. In July, you all heard about Professor Robertson's recommendations for how to implement changes based on his interpretation of Professor Farkas's research. And just as a reminder, Professor Farkas's research on the impact of the discipline system found that Black male attorneys are disbarred and placed in probation at a rate higher than those of their white male counterparts. And the relationship between outcomes and race appears to be related to a number of complaints, the fact that African-American male attorneys are less likely to have counsel when they were under investigation, and they tended to have more prior discipline complaints than white male attorneys. So Professor Robertson looked at that research and proposed a number of reforms. And at your July meeting, you recommended that, or you directed staff to develop 5 projects, and these are them. The first project is to archive 5 years of close complaints from VIEW so that staff don't consider them when viewing new complaints. You also directed us to start research on complaints that don't lead to discipline. You directed us to pilot test letters to encourage respondent representation. Also to develop a metric that would track and report respondent representation. And then finally to do research on RA bank matters and implement an interim reform. So what I'm going to do is I'm going to go through each one of these projects to give you an update on the status of each. But before I do, I'd like to share that staff consulted with RAD leadership, Trustee Stallings and Trustee Duran on most of these projects, and we thank you for their invaluable insights. Okay, so let's start with the project that asks OCTC to archive 5 years of closed complaints. In particular, the direction was to implement an interim reform that prior closed complaints more than 5 years old should not ordinarily be considered in evaluating and investigating a new complaint, with exceptions. So here's the update. Immediately after your July meeting, OCTC staff were notified by Chief Child Counsel Lawrence that this directive was effective immediately. My office, in partnership with OCTC, identified over 500,000 closed complaints that can be archived from view. Right now, we're considering specific categories that need to be resolved. And the Office of Technology initiated a discussion with Tyler Technology, which is the vendor that operates Odyssey, our case management system, to come up with a way to automate archiving all these complaints, because it'd be really, really hard to do this by hand. So staff continues to work on this project and will keep you apprised of its status. Okay, so you also directed us to conduct research on complaints not leading to discipline. This flows from Professor Robertson's proposed that we explore a proactive non-disciplinary system to support attorneys at high risk for future complaints, particularly for complaints that do not lead to discipline. This potential reform dovetails with the work of the 2020 Governance and the Public Interest Task Force, whose final report recommended analyzing closed complaints to identify attorneys at risk of future complaints. And Professor Robertson recommended exploring closed complaints to inform the development of such a system as a first step. So my office has initiated data exploration and knowledge gathering in partnership with OCTC. The goal is to present a report in January 21 with our findings and recommendations for alternative interventions. And then we would spend 2021 pilot testing and exploring those interventions. I went ahead and combined the projects with regards to respondent representation. That is the directive to develop a letter that would be sent to attorneys, respondents, advising them on the importance of having counsel, and also to develop a metric. So let's see. The status is that we decided to develop a letter to give to respondents immediately. So rather than pilot testing alternative letters and then issuing a letter, we decided to issue one immediately. And then so we're operating on two tracks. First, we will issue one immediately, but then we've outlined a plan to pilot test letter alternatives. We'll do that in fall and winter, and they identify the most effective letter by 2021. And what we mean by that is that we're working with Professor Robertson, who is very experienced in exploring how language is influenced by behavioral concepts, psychological behavioral principles, and how if you phrase things a certain way, you can get people to act. And we're really excited about this continued partnership with Professor Robertson. Staff will initiate conversations with the Association of Disciplined Defense Counsel and State Bar Court. That was also part of the directive that we start these conversations. And with regards to a metric, my office is currently exploring all the data available. We've initiated conversations with OCT on the best way to operationalize this metric in a way that's meaningful. In particular, there's different ways to think about this. So for example, we need to talk through and think through at what stage of the entire process is representation most important. And then we have to see if our Odyssey database captures the information when we need it. So this project is on track. Okay, finally, let's get to RA Bank Matters. You directed us to evaluate RA Bank Matters because Professor Farkas's report found that among attorneys with large numbers of complaints against them, blackmail attorneys were more likely to have a large number of reportable action bank cases. So you directed us to understand the impact of this, of what it would mean if we modified the de minimis threshold for closing RA bank matters. So you asked us to evaluate the volume of RA bank matters organized by the amount of the overdraft, whether or not low RA bank matters are useful as predictors of subsequent misconduct, and whether modifications of rules to allow attorneys to place a specific amount of money in a trust fund would have any impact. And you asked us to, in particular, to evaluate the results, adopt a possible interim reform, and give you an update on where we are. So first, let me describe the analysis that my office undertook. We analyzed more than 100,000 RA bank cases ranging from 1991 to 2018. These ranged from 5,000 cases per year in earlier periods in this big time period to more than 2,000 cases in recent years. Ultimately, these 100,000 RA bank matter cases represent around 22,000 attorneys. In recent years, this is less than 1% of all active attorneys. And if you look at these 22,000 attorneys, when they had an RA bank matter triggered against them, 44% of them, that was their first one. 43% already had 1 to 5 cases, and around 7% already had 10 RA bank matters. So you asked us to understand what is the volume of RA bank matters by the non-sufficient funds NSF overdraft amount, and that's what this chart shows right here. The median non-sufficient funds overdraft amount is around $440. Nearly 1 in 5 was under $50, and more than half had a negative balance of over $500. We looked at the relationship between the number of RA bank matters and disposition outcomes. And what this chart shows is that the majority of RA bank cases are dismissed. That's the bar called total, the one on the far left. And the risk of discipline increases with the number of prior RA bank cases an attorney has. So as you can see, attorneys who have over 21 or more cases, they have the highest share of over 50% of them were disciplined. But what you asked us to really understand, which is, are these low-level RA bank matters useful predictors of subsequent misconduct related to client trust accounts or any other misconduct? So to answer that question, we conducted a multivariate analysis that predicts discipline, and we controlled for the overdraft amount, the number of prior cases, years of practice, length of time between these RA bank notices, because what we found is that many of them tend to come in clusters. And we also controlled for the allegations such as commingling, misappropriation, and moral turpitude. And what we found was that the chance of a respondent getting a disciplined is greater when the amount of the non-sufficient funds overdraft is smaller. What this chart shows is the relationship between the amount of the overdraft and the likelihood of subsequent discipline. Each one of those colored bars represents a category of people who, by their number of priors. So if you look at the blue bar at the bottom, remember I told you how people who had no priors before, most of them were not disciplined. So many of them were not disciplined. There are the blue bars. You can see it doesn't matter what the amount was. They still were less likely, very low likely predicted probability of getting disciplined. And in particular, though, what this shows is that the smaller RA bank amounts appear to be useful predictors of subsequent misconduct. So our recommendation is that there should be no change at this time to the policy regarding the de minimis amount that would trigger an investigation due to the public protection responsibility that the State Bar has. Instead, we recommend that OCTC explore proactive preventative approaches for attorneys who experience many low-level RA bank matters. Right now, the OCTC responds to these RA bank matters in a variety of different ways, including sending warning letters and research letters. So that's something they can do, is revisit how they deal with these, how they respond to them, and explore alternatives for change. And just to close the loop with regards to the recommendation or the directive to explore the option of modifying rules to allow attorneys to place money in client trust accounts, given the recommendation not to change anything, we did not explore that at this time. Okay, so the whole lead up of this memo gets to a recommendation, which is that given all this work that we are doing, that OCTC is doing, that my office is doing, in partnership with people across the organization, it's really time to take a comprehensive look at the attorney discipline system. And they will do three main things. This commission will do three things. First, as all these reforms are being implemented, and all this research is being conducted, they would review all this. They would review these reforms, all of the other OCTC reforms that have been done, and research studies that are in progress and have been completed. They would review it, make recommendations for more research or more additional reforms. And then also they would identify the processes, policies, procedures, and areas of the discipline system that need examination. So we have this really interesting chart that flows around. It's part of our ADR report, but it really maps out the entire the complaint process. And so my thinking is that this group could look at everything we've done, all the research we're doing and have done, all the policies that have been changed. And then there's probably parts of the system that we haven't looked at yet. And that would be this group's charge. And then finally, they would recommend, like I said, additional research and reforms. So the recommendations for this agenda item is that staff will continue to report out on projects and regularly update you. OCTC will explore proactive preventive approach for attorneys who experience low-level bank matters. And we also ask that you direct staff to develop this ad hoc commission on the attorney discipline system for your consideration at your next meeting. And with that, I'll take any questions you have. I know that Ruben was interested in having a discussion about the RA bank matters. I'm sorry, about the archive 5 year complaints. We can talk about that, but I will stop for now. Thank you.
All right, Lisa, thank you very much. Appreciate that very fine presentation.
Thank you.
Anyone on the board have questions for Lisa? Just to make a comment on the obvious or somewhat obvious, the recommendation regarding looking at reportable events and trying to identify people who may benefit from some preventative intervention tracks very closely to the work that the Government and the Public Interest Task Force did earlier this year. And I'm not surprised that that good work is already bearing some fruit. So I think this is a very well thought out and very beneficial suggestion. Yes, Josh.
Yeah, someone remember I commented on this last time, and I think I appreciate, Lisa, I think we're heading in the right direction, and it may just be semantics, but the term explore is just maybe not as proactive as I was hoping. And I'm wondering why it seems like a pretty clear link why we wouldn't lay out recommendations coming forward. I'm just concerned that that sends a message that we're just going to continue to study it. And I feel like we're at a point where we could take a step forward. There's clearly some education that needs to exist with these folks that continue to offend. Was that thought about when you used that term?
Actually, yes. Because are you talking about the RA Bank Matters?
I am. I'm sorry. I should have been more clear. Yes, your second recommendation, RA Bank Matters.
Yes, I believe it's because OCTC does have a strategy in place. They do these matters in a variety of ways, including sending warning and resource letters. The reason we use Explore is because I feel we should do some analyses of how their different strategies are working for now. So for example, we could do an analysis on all the respondents who received a warning letter or a resource letter regarding our RA Bank Matters, to see the extent to which they receive another complaint regarding that. We need to see what they're doing now and how effective it is now before identifying alternatives that may be drastically different. So that's the reason why we say explore.
And maybe I don't completely understand the timing of Professor Robertson and Farkas's studies, because I feel like that, if I remember correctly, my best recollection is that they looked at evidence from not that distant past in those studies. And I think that I felt like at least that there would have been time to see some of the changes that OCTC made come to fruition. Am I mistaken in the timing maybe?
No, I believe the analysis that Professor Farkas did was he simply showed that African Americans were more likely to have RA bank matters than white attorneys. That's what he showed. And I believe Professor Robertson took that result, was interested about it, did a lot of learning about it, talked with OCTC folks about it, and he came up with his recommendation to propose alternatives. So we explored that. We explored the alternative, and here we are. So now we're exploring and we're offering another alternative. I guess to me that's the order of things.
And if I might jump in here just for a moment, just to ask a clarifying question, Josh. So were you thinking that we had an analysis that looked at the impact of what OCTC currently does to handle the RA bank matters?
I think it was expressed at the last meeting, and I feel like we're just kicking the can, to be honest with you a little bit. I know everybody wants to make the right decisions, and I understand that, but we clearly have seen the disparate impact, and I feel like we need to take some action. And it seemed to me that there was some easy action to be taken. These are folks that continue to have these matters, and we've seen that by the number of these violations, there is obviously a through line to future discipline. And so I'm not understanding why we can't have a system of intervention earlier. And maybe I'm just missing it because I'm not maybe as well versed as some on this call. And that intervention is more than a letter, letting them know that they have a violation. And I'm just trying to figure out why I'm missing something here.
Let me just respond. It looks like you wanted to respond as well, Lisa. But I do think that what you suggested about it possibly being a matter of semantics and by explore, what exactly do we mean? One of the things that I don't fully understand is the extent to which and the exact threshold at which a respondent attorney will get a warning letter, because you're correct. In some cases, it's a letter and it's a notice like, hey, we've been receiving bounced checks. We've been receiving notification of this. And the point at which that would then become a referral to client trust accounting school. So in terms of the interventions that are available, there is a client trust accounting school that is that is led by OCTC staff. So I think in terms of the exploration, part of what we would want to do is say, at what point do we, perhaps we lower that threshold. Perhaps we say the client trust accounting school really needs to be like offered and even encouraged, if not maybe mandated, if that's a possibility under current rules, to people who are seriously at risk for these low-level bank matters becoming more serious misconduct and discipline down the road. So but what the final point about this though is that what Lisa said about like wanting to explore like the efficacy of these programs is we really don't know whether client trust accounting school itself is a great, does that result in people being less likely to bounce checks or not? And we don't know the impact. So I think all of these things kind of have to happen simultaneously.
Right. So on my last question, I'm sorry, Brandon. My last question, Dag, is how long until we do know? Because at some point, and I hate to be an agitator here, but at some point it just can't continue where we're going to look at this next year or the year after and say we don't know and we still have the same disparate impact.
I can't give you an exact date. I mean, I think we got very lucky with the data that were available on the RA Bank Matters, because the legacy data allowed us like 20 years, a very like big data set of, with all of the details that allow us to do the quantitative research and look at these relationships that Lisa talks about in the report. The exact timing of how long it would take to mount the study and to do the work in terms of like understanding what the impact is of client trust accounting is going to depend upon what the data look like. And whether operational reforms can take place and whether OCTC has arrows in its quiver with regard to mandating a client trust accounting school, even not knowing the exact impact of it, I don't know exactly. So I suspect that that's a pretty unsatisfactory answer, but it is the honest answer that I have.
So, well, actually, Brendan's been waiting to talk, so before I defer to him first.
Okay.
So Alan, it might be helpful to get Steve's comments on what is currently being done at OCTC in regards to RAs. I know it's been a couple of months since the last meeting, but just to refresh our recollections as to the current steps that are being taken and then that path forward that we're talking about now.
Okay, Steve?
Sure. In many cases, bank RAs are closed at the intake stage after reviewing the attorney's response. That's one of the rare occasions where we actually reach out to the respondent's attorney to get their position on the matter in intake. We don't do that on other types of cases, but we do on bank RA matters. Matters can be closed outright or with an alternative to discipline, such as a resource letter or a warning letter. Staff will usually issue a closing letter when the attorney's response showed that the client trust account check was mistakenly issued, an automatic payment was mistakenly linked to the client trust account, the attorney relied on the bank's indication that deposited funds were available, or the attorney is a victim of fraud. A case may close with a resource letter where the attorney disbursed funds prior to depositing entrusted funds into the client trust account, provided a client with a post-dated check and asked the client to wait to deposit that check, or the attorney made an accounting error that would have been realized with a monthly reconciliation of that client trust account. The case may close with a warning letter where there is a clear violation, such as failing to promptly withdraw attorney fees from the client trust account or failure to conduct monthly reconciliations of the client trust account. A warning letter can also issue where the attorney previously received a resource letter. And of course, we also have the discussion about de minimis matters and things like that that we've discussed before. So those are the circumstances that we do in fact issue resource letters, warning letters, and have different sort of tools in our toolbox. We also have, although it's not generally done in intake, we do have warning letters where the client trust account school is included as a condition of that warning letter. And so we do have the ability to do that as well, although that, as I mentioned, is generally not done in intake. It's generally more done once the case reaches the investigation stage, if it closes there.
So then as far as what your what the recommendations are as far as going forward, which do you see as being the most efficient, or can you even say that at this point, given the lack of data?
To be honest, I don't know, and I'm relying on Oriya a little bit here to make some suggestions based on the data, and what I have heard from them is that they don't have sufficient information at this point. One of the things that I would point out, and I completely understand, Josh, where you're coming from, that OCTC doesn't want to see this drawn out for an extended period of time and to continue to have a disparate impact either. I would point out that it may be that these efforts at education, which is what all of these somewhat rely on, the resource letter points to client trust accounting school and says, hey, you might want to take a look at this. The warning letter says, hey, we're concerned that this may have been a violation. you may want to take a look at client trust accounting school, et cetera. Or even at the investigation level, it says this is a warning letter and you need to take, and if you don't, we will reopen the case. But as Professor Robertson said, I believe in front of the board at one point, that at some level, it may not be an education problem. It may not be a situation where somebody is not aware of their obligations, but there's something else that precludes them from complying with their obligation. They may know, for example, that they're supposed to reconcile their client trust account, but on a monthly basis, but there may be some lack of support within their office, lack of resources, whatever it is, that prohibits them from doing that. And so there may be some other step that we need to look at in order to resolve this issue.
You know, and just something to follow up with regarding the report on page 7. One of the things that I think is particularly instructive is figure 1. And after looking at the data, staff found that the chance of a respondent getting disciplined is actually greater when the amount of the NSF overdraft is smaller. And so that really was in a contradiction to what we thought going in, that the data would show. And so then up to a negative balance of approximately $100, the discipline risk increases as the amount of the overdraft increases. And so, you know, one of the things we talked about 2 months ago, and we've continued to discuss at the chair and vice chair of RAD level in our meetings with staff, is this canary in the coal mine situation where we use these RAs to determine if, you know, a letter can be sufficient, letter of instruction, or if there's more serious misconduct, and this is just a chance for us to catch a glimpse of that misconduct. So I don't know, Dag or Lisa, if you want to flesh that out a little bit more for Steve.
I think in part what it sounds like you're referring to is where I think that this issue is especially tricky, because we do see disproportionate impact on African-American attorneys in the area of RA bank matters. It's an odd one insofar as where we see disproportionate complaints, we believe that that's related to some form of implicit bias or some sociological phenomenon that you know we can't exactly pinpoint. But with the RA bank matters, it's a threshold, it's an objective indicator that the banks send to OCTC. And what I think is happening is that we have unmeasured variables. We have issues of what the practice area is, who the clients are, what the sizes of the settlements are, and what the amounts are that are at play here. And because we don't have data on that, what we're seeing is we're just seeing this top level of these RA bank matters coming in. It also has serious public protection implications, and this is the issue that I think we need to figure out how to balance with the efforts to decrease the disproportionate impact while not sacrificing public protection. And I think that that's where I felt that the recommendation with regard to moving proactively and creating a more preventative solution in terms of seeking to support the attorneys while we're simultaneously protecting the public was a good way of wrestling this one to the so if, as Josh suggests, and I appreciate the comments, I think, you know, if there's a way that we can do that more expeditiously, and if we can handle on exactly what it is that we would do, maybe whether it's mandating. I don't want to get into what we could do in terms of mandating client trust accounting school or being more forceful or what that would look like exactly, because I simply don't know.
Sean?
Well, the one thing that maybe it's just me, but my head is spinning a little bit. We've gotten so into the weeds in this, but I just wonder if we've lost the forest for the trees for a moment, because and I may have this totally wrong, so someone can correct me, but I thought how we ended up here was that Professor Farkas found a correlation between disparity for Black male attorneys and the rate of serious discipline. And then he ultimately linked that to one of the factors that led to that was a record of prior discipline that seemed to have some effect on the trajectory of any individual attorney. And now we have found that, and then drilled into a higher incidence of these RA bank matters for Black male attorneys. And then we've discovered that the low level insufficient fund items are a predictor of future discipline. And what I didn't realize before in thinking about this, but it just occurs to me now is, I mean, is this kind of a chicken and the egg problem, so that if African American male attorneys, for reasons we still don't understand, have a higher level of these small NSF items, is that influencing the later discipline? In other words, is it, I don't think we can be confident based on this data that the subsequent discipline is independent of the RA bank items, which is the whole reason we ended up here in the first place from the Farkas study. So that's a question. And then I guess I'll just throw out everything. So that's a question to the staff. Second point I have is, Josh, you thought there were some easy solutions, I think, or use some similar language or interventions. So I wonder what you have in mind there. And then the third thing is, and this is all related, that staff and I had some back and forth about this before the meeting, but I think we should keep on the radar having COPRAC study whether to allow attorneys to have a cushion of funds in the trust account that would help prevent these small overdraft items. I think, I don't want to get into that here. I think there are actually some important policy considerations on both sides of that question to consider that are kind of wonky and not something that we should spend our time discussing today, but I think that's worth looking at. So I'll just throw that may be something we want to ask COPRAC to do sooner rather than later, because the recommendation has sort of pushed that to the side, and I still don't understand why that is the case.
All right. Yes, Donna.
So, and Lisa and Dag have heard me say this about 6 times, so they're going to roll their eyes. But following on what Brandon was saying and what Sean was saying about page 7 and the what's the word I'm searching for? The unexpected conclusion that that a respondent's chance of getting discipline is actually greater when the amount of the NSF overdraft is smaller. I think one of the things that seems to be missing to me here is, looking at everybody who has an overdraft of $50, everybody who has an overdraft of 100, everybody who has an overdraft of 500, whatever the right buckets are, is the sort of, everything else being held equal, are African-American male attorneys being forwarded for investigation or being disciplined based on that level of overdraft more than their white male counterparts? Because I think that gets to in my head, that's where the underlying question came, right? So Farkas, Professor Farkas identified that African-American male attorneys were getting more complaints. Some of them, many of those are complaints from outside of the system. They come into OCTC, but the RAs were ones that that Dag, as you said, there is not it's an objective threshold of them coming in. So there's likely no implicit bias in the referral of them to OCTC, but is there implicit bias in the referral of them from intake to investigation? Are we treating African American male attorneys the same, all things being equal? The amount of the overdraft, the numbers of prior of RAs, are we treating them equal to their white counterparts?
So I have another probably unsatisfactory answer because it's kind of a methodological answer, which is that I don't think we've set the data up to do that to answer that particular question. And so that would be a matter of like having matched samples. You'd have matched sets of data which on all of the relevant variables appear to be the same except on one of the variables, and that would be a race ethnicity variable that would allow you to try to like look at what that says. My general understanding about the way the data are currently structured and what we did look at is that it doesn't get at that level of granularity with regard to looking at this group of people who had the low level, the small amount overdrafts. Was it exactly that overdraft that resulted in the discipline? But my general sense is that that is not the case. And I think that the concern here is also that a concern that I've had is that I think that there's been a bit of a misperception that was generated in the July meeting that somehow these low-level bank matters were themselves the cause of the discipline. And generally, what I think we're seeing in the data is that it's not a $50 overdraft that is resulting in discipline. It is a $50 overdraft that is giving us, and then in combination with subsequent and sometimes groups of $50 overdrafts, that when you track that attorney and you track the small overdrafts as a variable on that attorney, and then you look to see whether that attorney was disciplined subsequently, that's what you're seeing. So to be more precise in our language, it's not subsequent misconduct, it is subsequent discipline. That's something that's been pointed out, which I think is important to keep in mind. But it's not, when you do this type of data analysis, it's very tricky to keep on sort of refining those variables till you get to the point where you're saying, oh, it's this $50 overdraft that is leading to this discipline. It's just the way that the data are structured is rather difficult in this regard.
Right. Can I just, this is a footnote. This is what I was getting at with my first point earlier, and it may not have been clear, or it's related, I should say, Dag, is that, one of the things the Farkas study suggested is there's a snowball effect, which makes perfect common sense. So that when OCTC, and Steve may have something to say in this, when OCTC is looking at a complaint, one of the things they're going to do is look at that attorney's history. And if the attorney has a history of having gotten 10 warning letters about insufficient funds checks, that could influence the decision about how to handle this new complaint. And that was the sense we were left with from the Farkas data, was that there was this snowballing, so that if we, so I'm not sure we've ruled that out or done anything about it. And if that is in fact contributing to the disparate outcomes, then we need to figure out a way to address that. And I'm not sure we're zeroing in on that. And so maybe I'm missing something, but it seems like the discussion, we somehow have gotten away from that correlation that Dr. Farkas identified.
I think with regard to the possibility of there being a snowballing effect here with the RA Bank matters, I don't think, I do not have the data to support this, but I don't think that we're talking about, say, a snowball of $50 overdrafts that result in severe discipline. Now, this is something we should look into. But what I think we're seeing on the subsequent discipline that is flagged as having been disciplined for an attorney who was previously flagged as having these low-level overdrafts, we're seeing rather serious charges against the attorneys, things like commingling, things like misappropriation of funds. So if what we're seeing is disproportionate discipline on this, I think what I would be concerned about doing is seeing if we couldn't do a better job of flagging the white attorneys who perhaps, for whatever reason, in terms of OCTC's processes, if that's the issue, if the disproportionality is coming on the other side, perhaps we have white attorneys who are getting away with things that they shouldn't be getting away with because there isn't that snowball effect of the small overdrafts. But I'll say it again, I think that there's a structural issue here in terms of the practice type, the amounts of funds that has us in a situation where we may not be looking at sort of implicit bias, but rather structural inequalities within the system that are leading to this effect.
Okay, thank you. Yes, Josh.
I'm just going to bring it back around to the beginning, and I apologize. My comment was that the word explore sometimes to me means that someone's putting it on the slow train. And I guess what I'm saying is I'm unsatisfied with where we are today on this. And I think that there are a number of issues, Sean, I think there's a whole bunch of different ones that come out of this that we need to understand and need to take action on. And so if I could say anything, it's that I interpret the word explore to do so in the most expeditious manner. And you know, that whether it's the same violation, whether it's just a signal and it's the canary in the coal mine, there may be more for us to do than just send someone to, and I don't mean that pejoratively, like that's not enough, but to send them to a trust fund school. I mean, there may be a larger intervention that needs to take place that says, historically, we've seen that these types of violations manifest into something larger. Let's work through what that is and how we can help you so that doesn't happen. And I just don't know that we have that hands-on approach today. And I think that should be one thing we should be thinking about how to do.
All right, Josh, thank you. And thank you for flagging the this issue. Does anyone else have any comments at this point? All right, it seems to me that Josh has raised an important point, and I certainly understand where he's coming from. I see, just to go back to the original, I see there are two places in these resolutions where the word explore is used.
Excuse me, this is the secretary. Would you like me to project the resolutions at this point?
Yeah, sure. Yes, please. Thank you. So in the first further resolved, you'll see that in the second line, Office of Chief Trial Counsel will explore options for a more robust, proactive, preventive. And then in the next further resolved in the third line, the Board of Trustees directs State Bar staff to develop plans to establish an ad hoc committee. In so doing, the staff will explore size, structure, and composition. One thing that we could do is after each explore, we could put expeditiously or some other word like that. And the other issue is the final further resolve sets the outside time table for providing the findings and recommendations to it's almost 2 years from now. So my first question to Donna is, has that timeline been well thought out? Is there a way of accelerating that? I mean, this is obviously not the only issue that the board faces and that the bar and staff faces. We have admissions and you know, bar examinations that are going to continue to rattle around for a while. We've got a lot going on, but would there be a tighter time frame that might be more acceptable to the board than the one that's included in this proposed resolution?
And I would just note that that the timeline was intended to give the commission the opportunity to fully complete its work. However, we can be crystal clear that the commission is encouraged to provide recommendations on a flow basis. You know, some way to really send the message that we are not looking to wait until June 30, 2022 in order to first get recommendations. But if they've got recommendations earlier in the process, then those should absolutely come to the board and be implemented.
Okay, Josh, with those a couple of changes, the modifying explore and putting some language in the final further resolved regarding trying to get the results to the board earlier than June of 2022 be satisfactory to you, or do you have any other suggestions that might be better for you?
It would. I would ask Donna. Alternatively, I personally find if you set a date earlier with the ability for people to extend when they need it to be a little more sufficient than giving them the longer time period. So if you would consider setting the date for a year earlier or sometime in that frame so that we can get people to understand the importance, and then knowing that we can obviously extend if we weren't able to finish the work.
Yeah, I have absolutely no concern about that. I think we could change it to say June 30th, 2021. You know, and note that it would be, you know, subject to, you know, extension by the Board of Trustees if necessary.
Right. How about
Or
that?
or just have that last part be implicit, frankly.
Now let's put it in.
Mr. Chair, this is Arnie. May I also just sort of ask just a question as it relates to this as well?
Yes, go ahead.
You know, obviously, this is my first meeting and the first time I'm really sort of spending a little bit of time with this particular subject matter, and clearly these correlations are very sort of troubling. I too share my colleague from the Senate, Mr. Josh's sort of concerns about the need to move expeditiously on this particular matter, and would also sort of find that moving up the timeline to 2021 and in June would be a lot more sort of satisfactory to me as well. However, I'd also just sort of add, I wonder if there's a way that we could get some sort of milestone, sort of interim milestone sort of reporting on this as well, so we don't have to wait till to June just to see how things are going. Is it possible that you know, 3 months in, 2 months in, something to that effect, we might be able to at least hear how things are going, if there are some interim sort of some findings, recommendations that we might be able to act on at that time as well?
We could say with periodic status updates to be provided to the State Bar Board of Trustees at each regularly scheduled meeting beginning in March or something like that, March 2021.
And Mr. Chair, if I could, so the chair and vice chair of RAD were tasked with keeping our fingers on the pulse of what was going on with these projects and communicating with staff about you know, any sort of direction that they needed or any sort of policy decisions, and then really how to be as efficient as possible in looking at and you know, examining the data, what we're seeing, and then trying to be really proactive regarding what we find out from that day-to-day basis. So I think it was a good setup, and I think it was a good process. So I would recommend that we continue to do that, a similar process going forward with the new chair and vice chair.
Okay, I'm sorry, Brandon, you were cutting out a little bit. Do you have a specific wording that you wanted to add or change, or just wanted to make that comment? I'm sorry.
I don't know if anybody's made has moved the item yet, but
no.
Add that in the first resolution.
The initial resolution?
Yeah,
okay.
Yeah, the initial.
Going back, yep.
So perhaps where it says resolved, that staff will continue to work on projects, and then in conjunction with RAD chair and vice chair.
Of RAD?
Yes.
And I should note that I would expect this to come back to the board sooner than March, in part because the Governance Public Interest Task Force is charged with coming back with looking at proactive risk-based regulation recommendations at the January planning meeting. This seems to fit right into that bucket and provides us with, I think, a potential win in that space.
Donna, does that seem reasonable to you?
So the only issue would be the this commission will be but so as I look at it, we've provided you a charter, if you will, in this agenda item. So What I think would make sense is if staff were to solicit nominations to this commission between now and the November meeting. The way the agenda item reads, it suggests that maybe we come back to you in November, then you authorize the commission. Like, this is the establishment of the commission. And so we come back to you in November with the members. I mean, January, they will have, maybe had the opportunity to meet, once. So it wouldn't really be an update from them necessarily if you're doing it in January, because I don't know how much opportunity they'd actually have to meet. But it's certainly appropriate for us to provide you that update though.
Okay. So January 2021, Ms. Secretary. Thank you. Brandon, is that good for you?
Yes, and I think what's important to note too is from the previous meeting, I would anticipate that the RAD chair and vice chair will give an update every single meeting as to the Robertson recommendations and the status of them, because I know that they.
That's fine. I don't suggest we put that in the resolution. Let's put that as part of your work plan, if we will. All right, Josh, does that remove your major concerns? Is this acceptable now?
It is. Thank you.
Does anyone else want to make any comments on this revised resolution as now presented?
Chair, I'll move the item.
All right, moved by Stallings.
Second.
Second by Pertula. Any further discussion? All right, Madam Secretary, please call the roll.
Broughton,
Yes.
Chen, Cisneros,
Aye.
De La Cruz,
He's had to excuse himself temporarily.
Ellen,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron, Pertula,
Yes.
Selig,
Yes.
Sowell,
Yes.
Stallings.
Yes.
Motion carries.
All right, thank you very much. Josh, thank you for your comments and suggestions, and thank everyone for working together to get this resolution passed. Good job.
Chair Steinbrecher, if I may interrupt just long enough to take off my research hat and put on my board support secretariat hat, I wanted to do a quick bit of housekeeping. I like to send out the links as close to the time when you will actually use them as possible. So I've been holding off on sending out the closed session link. I'm about to send that. So your closed session link will be arriving in your inbox. Start counting down. I'm hitting send right now.
Well,
Thanks
don't
so much.
anybody jump onto it because we're not there.
Exactly. You won't use it until the end of open session, but I'm sending it now so that you'll have it available at the top of your inbox.
All right. We're going to address the next two issues, and then we'll see if we need a short break. Agenda items 705 and 706 are both requests for approval of an exemption to CalPERS 180-day wait period in order to appoint two different individuals as retired annuitants under Government Code Section 21224. Presenting these two are Michelle Crampton, the clerk of the State Bar Court, and Jay Lee, Assistant General Counsel. Why don't we will move each of these separately, but why don't you go ahead and give your general remarks and get us through this. Michelle or Jay.
Good afternoon to the board. As set forth in the written agenda item, staff recommends that the board approve a resolution that will allow Marilyn Tishner and Janice Hausman to continue working for the State Bar Court as retired annuitants. Ms. Tishner will work for the State Bar Court in assisting it in its continuing implementation of its new case management system. The terms of the retired annuitant appointments for both Ms. Tishner and Ms. Hausman are set forth in the written in the written agenda items, and these resolutions would be required under the Public Employees Retirement Law before either Ms. Tichenor or Ms. Hausman could be appointed as retired annuitants. And with that, I'm happy to answer any questions that the board may have.
Are there any questions for Mr. Lee? Hearing none, the chair will entertain a motion. Yes.
This is Jose. I'll move the motion.
All right. Thank you, Mr. Cisneros. A second?
This is Sonia Dillon.
Second.
Seconding.
Seconded by Ms. Dellin. Any further discussion? Madam Secretary, please call the roll.
Okay, and this one is for Marilyn Teichner.
Yes.
Broughton.
Yes.
Chen.
Yes.
Cisneros.
Aye.
Dela Cruz. Dellin.
Yes.
Duran.
Yes.
Iglesias.
Yes.
LeBron. Bertula.
Yes.
Selig.
Yes.
Sowell.
Yes.
Stallings.
Yes.
This motion passes.
Thank you.
Mr. Chair, it's Jose again. I'd be happy to move the second motion.
Thank you. Moved by Mr. Cisneros. Second, please.
I'll
Yep.
second. This is Hylin.
Thank you, Ms. Chen. Seconded by Ms. Chen. Is there any further discussion? Madam Secretary, please call the roll on 706.
Janice Houseman. Broughton.
Yes.
Chen.
Yes.
Cisneros.
Aye.
Dela Cruz. Dellin.
Yes.
Duran.
Yes.
Iglesias.
Yes.
LeBron. Bertula.
Yes.
Selig.
Yes.
Sowell.
Yes.
Stallings.
Yes.
This motion passes.
Thank you. All right, we have two items on the open agenda before we go to closed. We've been going just under 2 hours. Would anybody like to take a brief, like 5-minute break?
Sure.
Yes.
Minutes. It's 2:43. Why don't we say 7 minutes and come back at 2:50? Thank you. That
Wow,
means,
two extra minutes. That's really magnanimous of you.
it's the flexibility for Ruben Duran rule.
There you go.
Short timing it.
Let us resume the board meeting in open session. We have two agenda items in open to go. 707 is changes and elimination of bias requirement in minimum continuing legal education. And that is going to be, I don't know, what did I do with my papers? Anyway, we have somebody speaking on that. I just don't know who it is at the moment. Would anybody like to volunteer to present this?
Yes, Chair Steinbrecher.
Erica, well, good.
You.
Welcome.
My name is Erica Carroll. I'm a senior program analyst with the Office of Access and Inclusion, and I'm here to discuss the proposed changes to the elimination of bias MCLE rules for both licensees and providers. These rules were approved to circulate for public comment at the board's meeting back in March 2020. And so I'll be reviewing the public's response as well as the Council on Access and Fairness and staff's recommendation for approval and adoption of the changes. Just to provide a little bit of background and context, the current MCLE requirements for attorneys are for attorneys to complete 25 hours of continuing legal education every 3 years. Currently, about 3/4 of that time is devoted to general credit, meaning attorneys can take courses in any practice area or topic that they choose, but there are a few specialized topics that are required. One of those being 1 hour of recognition and elimination of bias in the legal profession and society, and that is the topic that we'll be focusing on today. Under the State Bar's strategic plan, under Goal 4, which has the State Bar's diversity and inclusion objectives, there is Objective M, which is to modify the elimination of bias MCLE requirements. The most recent version of the strategic plan calls for the consideration of creating subtopics, expanding the hours requirement, and conforming to the timeline prescribed by Business and Professions Code Section 6070.5, which I will go into greater detail shortly about that statute. And it also calls for these changes to be completed by the end of the year. So Business and Professions Code Section 6070.5 was created by AB 242 at the end of 2019. Broadly, what it requires is the State Bar to adopt regulations requiring attorneys to complete coursework in implicit bias and bias-reducing strategies as part of their continuing legal education. And it also has requirements for providers of MCLE courses for those who offer implicit bias courses to meet certain requirements. And those are to make reasonable efforts to recruit and hire trainers who are representative of the diversity of persons that California's legal system serves. That trainers will have either academic training or experience educating legal professionals in implicit bias and its effects on individuals accessing or interacting with the legal system. All training on implicit bias should include components on different types of bias, so implicit bias, explicit bias, and systemic bias. And it also requires that providers include actionable steps in their trainings for licensees to recognize and address their own implicit biases. This statute requires these changes to go into effect beginning January 1st, 2022. So providers would need to comply beginning as of that date. Attorneys will not need to report their compliance until the reporting period ending on January 31st, 2023. So this is one change since the last time this was brought to the board. In its first iteration, it said that attorneys would have to comply beginning January 31st, 2024, but that wasn't the intent of the statute. And so the legislature recently corrected that at the end of August with AB 3364. And so now it will go into effect requiring licensees to comply January 31st, 2023. So taking into consideration the strategic plan as well as the new statute, the Council on Access and Fairness, which is appointed by the Board of Trustees and charged with assisting and advising the State Bar in defining and advancing the State Bar's diversity and inclusion goals. They took a look at these mandates and proposed certain changes to the minimum continuing legal education rules. First, they proposed increasing the elimination of bias hours from 1 to 2 hours every 3 years, creating an implicit bias subtopic, so at least one of the 2 hours of elimination of bias coursework would need to be devoted to implicit bias, mirroring the requirements I just summarized for MCLE providers, and to apply these rule changes on the same timeline as the Business and Professions Code Section 6070.5. And most recently, they recommended that that timeline also be updated as with the legislature's change in August. So this item was first brought to the Board of Trustees back in March with the proposed rules, and the board approved it going out for public comment. The public comment period was extended by 60 days until June 30th to allow everybody who wanted to participate ample opportunity to comment. And we received 31 comments in response to the proposed changes. All of the comments that we did receive were in relation to changes for attorneys. We didn't receive any comments in favor or in opposition of the changes for providers. So for those comments for attorneys, approximately 60% commented in favor of the changes. Among those comments, we received letters from 4 statewide organizations, which were the California Lawyers Association, the California Commission on Access to Justice, California Minority Counsel Program, and the Legal Aid Association of California. We took this to show some broad support statewide for the proposed changes. And in the comments that were received in favor of the changes, the main themes that emerged were support for promoting awareness of all types of bias in the legal profession, opening a dialogue about this topic, and improving experiences both in the workplace and for individuals interacting with the legal system. We did receive some comments that were opposed to the changes, and broadly they centered on not wanting MCLE to be devoted to more specific topics, preferring to have more freedom of choice, more ability to devote their time to the general credit. or there were a few comments where individuals didn't find MCLE, whether it was elimination of bias or otherwise, to be effective. But the hope is that with these proposed changes to the rules, that it will become more effective because the elimination of bias requirement will include actionable steps for licensees to continue this work after taking coursework in elimination of bias, as well as devoting more time to a topic that has a very broad, expanding knowledge base that is a lot of material to cover. And so giving more time devoted to the topic will allow licensees to get more benefit out of the training as well. So having analyzed the comments, the Council on Access and Fairness and staff are recommending that the board approve and adopt the proposed changes to the rules for both licensees and providers, with the one change to the date, the effective date for attorneys reporting their compliance.
Thank you very much. All right, does anyone have any questions for Ms. Carroll? Ms. Cohen, would you put the proposed resolution up?
Mr. Chair, I'll move the resolution.
Okay, moved by Mr. Stallings.
I'll second it. It's Chris.
And seconded by Mr. Iglesias. Is there any further discussion? Madam Secretary, please call the roll.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz, Dellen,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron, Petula, Selig. Oh, I'm sorry. Did I
Yes.
just? Okay, got it. Selig.
Oh, Sarah, that was me. That was Seleg saying yes.
Oh, okay.
Pertula, I believe, had to leave for a brief telephone call, so you did not get his vote.
Okay, thank you. Sowell,
Yes.
Stallings.
Yes.
Motion passes.
Thank you. And thank you very much, Ms. Carroll. Appreciate it. And thank you again. All right. The last item on the agenda for the open session is 708 regarding provisional licensure rule of court. And that's being presented by Highland Chen, the chair of the Provisional Licensure Working Group, and Donna Hershkowitz, our interim executive director. So please take it away.
Great. So we convened a provisional licensure working group to put together a proposed set of rules to give effect to the Supreme Court's directive that we come up with a provisional licensure scheme to provide provisional licensure for 2020 law grads who meet all the other eligibility requirements for admission to the state bar, with the exception of sitting for and passing the California bar exam. The working group reflected a broad range of attorneys from different sectors of the legal profession. We met a couple of times, came up with a proposed rule, which was then put out for a 15-day public comment period. I'm happy to summarize some sort of high-level takeaways from what the rules provide, but in general, they require that an applicant must have satisfied all the requirements for admission other than passing the bar exam. We did make a change with respect to the MPRE, given that that test is now is still administered in person only. So there is an alternative way to satisfy the MPRE requirement, which is by making sure that the applicant take the 2 hours of new attorney training on ethics within the first month of their being licensed. With respect to moral character, the applicant needs to have submitted a complete moral character application prior to submitting their application for provisional licensure, but that does not delay their entry into the program. If they receive an adverse determination, they'll be suspended or terminated. And we gave really broad discretion to the supervising attorney. So there was a lot of discussion around whether there should be limitations on what areas of law a provisionally licensed lawyer can practice, what particular things they can or can't do in court. And rather than trying to enumerate all the possible scenarios, we thought that it made sense to give that discretion to the supervising attorney. In response to public comment, we made a few changes, the most notable one of which was to reduce the fee for provisionally licensed lawyers. So the fee that is in the proposed rules is $55 for applicants with $75 with a 25% reduction for those who work for IOLTA funded organizations and no fee for those who are working on a volunteer basis. And I don't know if you have other stuff to add, Donna. As you may have heard, well, one thing, as you may have heard from public comment on the last day that the working group met to consider public comment, Neil Gupta suggested that we consider whether to make these provisionally licensed lawyer, make this program available retroactively to those who achieved a 1390 on prior bar exams. And given that we were at the end of our time, we thought that it made sense for these rules to come directly to the board for consideration and approval, and to set aside the retroactivity question for another date.
And I would just add that the plan would be to set a meeting in the very near future of the provisional licensure working group to consider that supplement, to see if they are going to recommend to the board a supplemental rule on that, on expanding the program to include those who got a 1390 or higher on the bar, on a prior bar exam, even though they were not 2020 graduates. Because that was beyond the scope of the direction that the Supreme Court gave to the state bar, and we know how important it is to move this rule quickly and get something adopted as quickly as possible. The working group thought it made sense to not hold off on this, submitting this rule to the court, but rather to see if after a full discussion they want to go, they recommend going in that direction. If so, they will send a follow-up recommendation to the board. The only other thing that I would add is what guided the working group in the considerations that they put together, that helped them put together the rule. The group was guided largely by the direction from the Supreme Court. The rules that have been developed in other states, I believe there are 24 states that have developed rules, the latest of which came out this morning on a provisional licensure program or an extension of their existing legal intern program, or expanding the equivalent of their certified law student program to law graduates. In addition, the working group relied on California's existing multi-jurisdictional practice program rules, such as the registered military spouse, registered in-house counsel, and registered legal aid attorneys. They looked at California's existing certified law student rules. They considered the desire to create a program that did not impose such significant burdens on employers that employers wouldn't subscribe to it. This was an important guiding principle for the group, is to make sure that we would create a program that people will utilize. And then the final item that I would mention, though absolutely not the last thing that the group took into consideration in developing the rule, was empathy for those who are graduating from law school, who graduated from law school in 2020, and others who've dealt with changing bar exam dates, environments that may not be conducive to studying or taking a bar exam, financial challenges resulting from the pandemic, health issues, and even the loss of life of family members. Those were all important guiding principles that the working group took into consideration in developing the draft rule.
Are there any questions for either Highland or Donna.
Your eagle-eyed incoming chair did notice two typos on page 2 of attachment A. At the very top, paragraph 1, subparagraph A, it should say in the second line, so it should say,
employer.
in the second line after $50 if the employer, and then paying the fee received, so taking out the word is. So just adding the word the and taking out the word is.
Okay.
Mr. Chair, if I may offer
Yes.
a few comments before the motion is made. I'm going to assume Highland's going to want to make the motion. I just wanted to say that I was fortunate enough to be involved in this working group, and I was extremely impressed with not only Highland's leadership and the support from Donna and Amy and the admissions staff, but the seriousness with which the working group members took their task. The conversations were substantive and lively sometimes, but always focused on the very difficult situation I think that these recent law grads are facing. And there was quite a bit of back and forth, and I think my mind was changed on several things several times. And so I found it a very, very rewarding experience in a very difficult time. And Highland, truly, you did such a wonderful job. Thank you for your leadership in that.
Thank you, Ruben.
Well, thank you, Ruben. And I really do have to thank Donna and her team for all of the hard work they put into putting those rules together. It does, as Donna said, reflect a wide variety of views, and we had robust discussion, and I think ended up in a good place.
And then, Alan, just one last thing that I will observe. It was very helpful to have non-voting liaisons from the Supreme Court, Mr. Gupta and Mr. Fontesquieu. The insight that they provided several times was pivotal, and so I just want to express my thanks to the court and to them in particular for their service on that.
Thank you, Mr. Duran. Yeah, I wanted to say the same thing. This directive to establish a provisional licensure program was very recently made, and I knew that it was going to require a lot of work and a lot of innovative thinking, and it had to be done well in a very short period of time. So I was delighted when Highland volunteered to lead this group. I knew that she would do it flawlessly and seemingly effortlessly, which is exactly the way it's worked out. I haven't heard much of a peep from the entire operation other than, okay, we're sending it out for public comment, and then here we go again, and now we're ready. So Highland, thank you very much for all of your efforts in that. We know you're a very busy person, but you managed to add this on, and it was very important, and you've done a great job, and we thank you very much, and your entire group. I do have a question, Highland. I know that you, as part of your working group, you tried to test the waters and see how many employment opportunities there might be out there for this program. And I'm just wondering if you have any current understanding of how many jobs there might be out there, or if you just don't know, then that's fine. I wouldn't want you to guess.
I would just be guessing, but we did endeavor to include in the working group a number of folks who come from what would be major employers, including from, for example, the LA Public Defender's Office, which is the largest public defender's office in the nation, representative from the California AG's office, and the like. And it does seem that there is interest in hiring recent law grads. I think there is a role for them, and it was important to hear their voices because they really tried to consider, making this program attractive to employers. It's hard to gauge when, different agencies and companies are making cuts due to COVID and the like. But we are hopeful that there are those opportunities out there. And one of the things that we discussed as a working group is working together with CLA, as well as with State Bar Communications, to make sure that we are educating employers, including through sending out a mass email to all State Bar members about this program so that people know that it's available, and to encourage folks to use it.
And I did, sometime between Friday and today, talk to the executive director of CLA, and they are on board with providing some webinars or opportunities. They are supportive of the program, and so they will present that view to whether it's, you know, representatives from the, you know, solo and small firm sections, or a variety of their members, and then we will be on to explain the program and address any questions that the employers have. So we were already talking about doing that maybe, you know, third week of October.
Okay, terrific. Thank you. Any other comments or questions? Yes, Mark.
A question on the last portion of the item where it talks about continuing to discover or look into the issue of retroactivity. I guess the Supreme Court has been pretty clear so far on whether they're going to be retroactive on the bar exam. So do you have to get a direction from the Supreme Court before you consider that?
So this would not be retroactivity of the bar exam. This would be.
No, I understand that, but just of this working group, but do you have to get direction from the Supreme Court to consider that item before you do it?
We do not believe so, based on the conversations that I've had with the principal attorney to the Supreme Court. He believes it would be appropriate for this group to talk about it and to make a recommendation to the court should the working group and should the board believe that that is the right direction to go in.
And if I could just add, Mr. Chair, that, and Eileen may have another view on this, but my impression of sort of the reaction among some of the working group members when the issue was put on the table was such that I think there is going to be more robust discussion about this very important issue, and the working group members are going to want to treat it with the seriousness that it deserves.
Okay, thank you. All right, Madam Secretary, were you able to insert the two changes that Mr. Saleg found?
I believe those are on the attachment and not in the actual resolution.
Yeah.
Oh, okay. All right. Very good. All right, then, hearing no further discussion requested, the chair will entertain a motion to adopt the resolutions as presented.
So moved. This is Eileen.
Highland moves.
I'll second.
And I'm sorry, was that Brandon?
I think it was Mark.
I think it was Mark.
Mark, okay, thank you. Mr. Broughton, thank you.
And Mr. Chair, this is Brandon. I am recused from discussions involving this topic. So I've walked away from the table, as it were, and will recuse myself.
All right, very, very fine. Thank you for letting us know, Mr. Stallings. Okay, Madam Secretary, please call the roll.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz, Dela Cruz.
He was unable to come back to the meeting.
Okay, thank you. Dellen,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron, Pertula, Selig.
I'm sorry, Madam Secretary, Mr. Petula is off the line for a while.
He's not present.
Correct.
Okay, thank you. Selig,
Yes.
Sowell,
Yes.
Stallings is recused.
He's recused.
Motion passes.
Thank you. That concludes the business of the open session of today's Board of Trustees meeting. as provided in Government Code sections 11126 through 11126.2, the Board of Trustees will be going into closed session to discuss agenda item 7001, which is I'm sorry. Oh, discussion regarding potential employment litigation against the State Bar, which is section 11126, subparagraph E, parent small 2B1. Item 7002, which is Government Code section 11126, subparagraph A1. And item 7003, Gordon et al. Versus State Bar of California, pursuant to Government Code section 11126, subparagraph E1. So we will be going into closed session. We'll come out of closed session into open to close out the entire meeting. I would imagine that that will be at least half an hour, and that may be a very general estimate. At this time, we can now go to the different link for the closed session, and we will see you there. 2, 3. We have enough. We have a quorum, and we are out of close. We are now ending the open session at 4:41 p.m. And thank you all very much. We can leave.
Thank you.
Thanks so much. Bye-bye.